We'll recall 20 CR 1358, People versus Letecia Stauch. Record should reflect the jury has returned to the courtroom. Good morning, ladies and gentlemen. We're going to start today like we have every other day. Has anything occurred since we were last together that causes any of you to believe you could not continue to serve as a fair and impartial juror in this case? If so, please raise your hand. No response? All right, when we took our break on Wednesday, we were in the midst of the defendant's case, so that's where we will resume. Mr. Tellini, call your next witness, please. Ladies and gentlemen, what that means is the defense has presented all of the evidence which it intends to present for you to consider the issues in this case. I want to remind you that the defense does not have any burden of proof at any point in these proceedings. However, because the defense did present evidence, the prosecution also has an opportunity to present rebuttal evidence if it chooses to do so, to rebut any of the evidence that was presented by the defense. With that, prosecution, do you have any rebuttal evidence? Ladies and gentlemen, what that means is that all of the evidence which you may properly consider to decide the issues in this case has been presented. Here's what we're going to do going forward. Mr. Combs has some instructions for you. He's going to hand those out. So if all of you would take one and pass it down. All right, the law in the state of Colorado requires that I read these instructions to you, even though you have them with you to take back into court. In addition, because you each have your own individual copy, you can write on your copy any notes that you want to have, just like you would any other notes. Those are not discoverable. Once the case is done again, those are destroyed. The original jury instructions that I'll give you at the end, those are the ones that need to be filled out. In addition, you'll also see that your instructions start with 9A. That's because we had an addition. So if you hold on to 9A, it's going to go right after instruction 9. Just hold on to it. We'll get there, I promise you. Okay. What we'll do is I will read these instructions, then we'll take about a 15-minute recess or so. Then we're going to come back. Then the prosecution has an opportunity to give you a closing argument. After that, the defense has an opportunity to give a closing argument. After that, then the prosecution has an opportunity to give rebuttal. It's much like rebuttal evidence. They get to comment on anything that the defense had to comment on in their closing argument. So that's the process. I want to tell you, we work almost always on a closing argument, from my perspective, a little bit on the fly, because I've not placed time limitations on the attorneys. However, I'm not going to have you guys sitting there for a 4-hour block of time either. So it may be that we do the prosecution closing, the defense closing, and take a break, a lunch break, and then do rebuttal. The other thing is that since we are here for closing, that means that this case has been concluded. That means that you will be here all day. Normally you have gone out to lunch, those sorts of things. That won't be happening today. We're going to order lunch in for you. When we take our break, we're going to have somebody come down and they'll tell you about the lunch process and stuff like that. But we're going to have you here today. And once we discharge you, or once we send you back for deliberations, you'll need to stay together for the deliberation period. Members of the jury, the evidence in this case has been completed. In a moment, I will read to you jury instructions that contain the rules of law you must apply to reach your verdict. You will have copies of what I read to take with you to the jury room. But first, I want to mention a few things to keep in mind when you are discussing this case in the jury room. Until you have returned a verdict, you must not do any research about this case or this kind of case using any source, including dictionaries, reference materials, the internet, or other electronic means. You must not communicate in any way with anyone else about this case or this kind of case until you have returned a verdict in court. This includes your family and friends. If you have a cell phone or other electronic device, you must keep it turned off during the jury deliberations. Actually, what happens is we collect all of those. You get them back at the end, and sometimes you even get back your own. But we collect them all at the end. Or we collect them all and we hold on to them during deliberations. It is my job to decide what rules of law apply to the case. While the attorneys may comment on some of these rules, you must follow the instructions I give you. Even if you disagree with or do not understand the reasons for some of the rules of law, you must follow them. No single instruction describes all the law which must be applied. The instructions must be considered together as a whole. During this trial, you received all of the evidence that you may properly consider in deciding the issues in the case. Your decision must be made by applying the rules of law that I give you to the evidence presented at trial. Remember, you must not be influenced by sympathy, bias, or prejudice in reaching your decision. You should not allow bias or any kind of prejudice based upon gender to influence your decision. If you decide that the prosecution has proved beyond a reasonable doubt that the defendant is guilty, it will be my job to decide what the punishment will be. In making your decision, you must not consider punishment at all. At times during the trial, attorneys made objections. Do not draw any conclusions from the objections or from my rulings on the objections. These only related to legal questions I had to decide and should not influence your thinking. If I told you not to consider a particular statement that was made during the trial, you must not consider it in your deliberations. Finally, you should consider all the evidence in light of your experience in life. The defendant is charged with committing the crimes of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with the deceased human body, and tampering with physical evidence in El Paso County, Colorado on or about January 27, 2020. The defendant has pled not guilty by reason of insanity. The charges against the defendant are not evidence. The charges against the defendant are just accusations. The fact that the defendant has been accused is not evidence that the defendant committed any crime. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove the dissatisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element of a crime has been proven beyond a reasonable doubt, you should find the defendant guilty of that crime. If you find from the evidence that the prosecution has failed to prove any one or more of the elements of a crime beyond a reasonable doubt, you should find the defendant not guilty of that crime. The number of witnesses testifying for or against a certain fact does not, by itself, prove or disprove that fact. You are the sole judges of the credibility of each witness and the weight to be given the witness's testimony. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. For each witness, consider that person's knowledge, motive, state of mind, demeanor, and manner while testifying. Consider the witness's ability to observe, the strength of that person's memory, and how that person obtained his or her knowledge. Consider any relationship the witness may have to either side of the case and how each witness might be affected by the verdict. Consider how the testimony of the witness is supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence when you evaluate each witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. A witness qualified as an expert by education, training, or experience may state opinions. You are not bound by the testimony of witnesses who testified as experts. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it, or none of it. The way you give the testimony is entirely your decision. Every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. It is not evidence, does not prove anything, and must not be considered for any purpose. The court has taken judicial notice of a certain fact. You may or may not accept that fact as true. It is entirely your decision to determine what weight, if any, shall be given to the evidence. And this is where the 9A goes. In response to the COVID-19 pandemic, the El Paso County Jail was accepting WebEx meetings on March 20 of 2020. The defendant's attorney had a WebEx meeting with the defendant on that date around noon. Later that day, Dr. Moore had a conversation with the defendant about Gannon being found in Florida. A fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Direct evidence is based on firsthand observation of the fact in question. For example, a witness's testimony that she looked out a window and saw snow falling might be offered as direct evidence that it had snowed. Circumstantial evidence is indirect. It is based on observations of related facts that may lead you to reach a conclusion about the fact in question. For example, a witness's testimony that she looked out a window and saw snow covering the ground might be offered as circumstantial evidence that it had snowed. Members of the jury, you may discuss this case only when you are all present, and you may only deliberate in the jury room. No juror should attempt to discuss this case with other jurors or anyone else at any other time except when all jurors are in the jury room. Once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to the bailiff, who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that, under the law, the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. Finally, please be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case and must be returned to me when you return the instructions and verdict forms at the end of the case. One other caveat to this instruction is that takes time because I have to reconvene the court, have to bring the lawyers in, we have to discuss the question, what the possible response is. So it's not as quick as the questions that we have when you're asking witnesses. During this trial, you were permitted to submit written questions to witnesses. If a particular question was not asked, do not guess why the question was not asked or what the answer might have been. My decision not to ask a question submitted by a juror is not a reflection on the person asking it, and you should not attach any significance to the failure to ask a question. By making legal rulings on the admissibility of questions, I did not intend to suggest or express any opinion about the question. My decision whether or not to allow a question is based on the applicable rules of evidence and other rules of law, and not on the facts of this particular case. It is my responsibility to assure that all parties receive a fair trial according to the law and rules of evidence. The fact that certain questions were not asked must not affect your consideration of the evidence in any way. Do not give greater weight to questions or answers to questions that are submitted by yourself or your fellow jurors. In making your decision, you must consider all of the evidence that has been presented. In this case, a separate offense is charged against the defendant in each count of the information. Each count charges a separate and distinct offense, and the evidence in the law applicable to each count should be considered separately, uninfluenced by your decision as to any other count. The fact that you may find the defendant guilty or not guilty of one of the offenses charged should not control your verdict as to any other offense charged against the defendant. The defendant may be found guilty or not guilty of any one or all of the offenses charged. A crime is committed when the defendant has committed a voluntary act prohibited by law together with a culpable state of mind. A voluntary act means an act performed consciously as a result of effort or determination. Proof of the voluntary act alone is insufficient to prove that the defendant has the required state of mind. The culpable state of mind is as much an element of the crime as the act itself and must be proven beyond a reasonable doubt, either by direct or circumstantial evidence. In this case, the applicable states of mind are explained below. The term after deliberation means not only intentionally, but also that the decision to commit the act has been made after the exercise of reflection and judgment concerning the act. An act committed after deliberation is never one which has been committed in a hasty or impulsive manner. A person acts intentionally or with intent when her conscious objective is to cause the specific result prescribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. A person acts knowingly or willfully with respect to conduct or to a circumstance described by a statute defining an offense when she is aware that her conduct is of such nature or that such a circumstance exists. A person acts knowingly or willfully with respect to a result of her conduct when she is aware that her conduct is practically certain to cause the result. These next instructions have to deal with the elements that must be proven for the charges, and it makes more sense once you actually have all of the instructions because it references in instruction 21. The elements of the crime of murder in the first degree after deliberation are that the defendant in the state of Colorado, at or about the date and place charged, after deliberation and with intent to cause the death of a person other than herself, caused the death of that person or of another person, and that the defendant's conduct was not legally authorized by the affirmative defense in instruction 21. After considering all of the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of murder in the first degree after deliberation. After considering all of the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of murder in the first degree after deliberation. The elements of the crime of murder in the first degree, child under 12, position of trust, are that the defendant in the state of Colorado, at or about the date and place charged, knowingly caused the death of a child who had not yet attained 12 years of age, and the defendant was in a position of trust with respect to the child, and that the defendant's conduct was not legally authorized by the affirmative defense in instruction 21. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of murder in the first degree, child under 12, position of trust. After considering all of the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of murder in the first degree, child under 12, position of trust. The elements of the crime of tampering with a deceased human body are that the defendant in the state of Colorado, at or about the date and place charged, believed that an official proceeding was pending, in progress, or about to be instituted, and, acting without legal right or authority, willfully destroyed, mutilated, concealed, removed, or altered a human body, part of a human body, or human remains with intent to impair its or their appearance or availability in the official proceedings, and that the defendant's conduct was not legally authorized by the affirmative defense in Instruction 21. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of tampering with a deceased human body. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of tampering with a deceased human body. The elements of the crime of tampering with physical evidence are that the defendant in the state of Colorado, at or about the date and place charged, believed that an official proceeding was pending, in progress, or about to be instituted, and, acting without legal right or authority, destroyed, mutilated, concealed, removed, or altered physical evidence with intent to impair its verity or availability in the pending or prospective official proceeding, and that the defendant's conduct was not legally authorized by the affirmative defense in Instruction 21. After considering all of the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of tampering with physical evidence. After considering all of the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of tampering with physical evidence. In this case, certain words or phrases have a particular meaning. The following are the definitions of those words and phrases. Accordingly, you are to use the following definitions where those words and phrases appear in the instructions and define crimes, defenses, special rules, and verdict questions. Cause means that act or failure to act which in natural and probable sequence produced the claimed injury. It is a cause without which the claimed injury would not have been incurred. Homicide means the killing of a person by another. Official proceeding means a proceeding heard before any legislative, judicial, administrative, or other governmental agency, or official authorized to hear evidence under oath, including any magistrate, hearing examiner, commissioner, notary, or other person taking testimony or deposition in any such proceedings. Person, when referring to the victim of a homicide, means a human being who had been born and was alive at the time of the homicidal act. Physical evidence includes any article, object, document, record, or other thing of physical substance. Physical evidence does not include a human body, part of a human body, or human remains. One in a position of trust includes, but is not limited to, any person who is a parent or acting in the place of a parent and charged with any of a parent's rights, duties, or responsibilities concerning a child, including a guardian or someone otherwise responsible for the general supervision of a child's welfare, or a person who is charged with any duty or responsibility for the health, education, welfare, or supervision of a child, including foster care, child care, family care, or institutional care, either independently or through another, no matter how brief, at the time of the unlawful act. The evidence in this case has raised the defense of insanity as a defense to the crimes of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with the deceased human body, and tampering with physical evidence. The defendant was insane at the time of the commission of the acts if she was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act, or she suffered from a condition of mind caused by mental disease or defect that prevented her from forming a culpable mental state that is an essential element of a crime charged. But care should be taken not to confuse mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger, revenge, hatred, or other motives and kindred evil conditions, because when an act is induced by any of these causes, the person is accountable to the law. In addition, diseased or defective in mind does not refer to an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Similarly, mental disease or defect means only those severely abnormal mental conditions that grossly and demonstrably impair a person's perception or understanding of reality, and that are not attributable to the voluntary ingestion of alcohol or any other psychoactive substance. Mental disease or defect does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. The law presumes everyone to be sane. However, after some evidence of insanity is introduced, The burden of proof is upon the people to prove to the satisfaction of the jury, beyond a reasonable doubt, that the defendant was sane at the time of the commission of the crimes charged. In order to meet this burden of proof, the prosecution must disprove, beyond a reasonable doubt, both of the above numbered conditions. After considering all of the evidence, if you decide that the prosecution has failed to meet this burden of proof, then the prosecution has failed to prove that the defendant was sane at the time of the commission of the acts, which is an essential element of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence. In that event, you must find the defendant not guilty and have the foreperson sign the designated section of Part A of the verdict form to indicate your verdicts. After considering all of the evidence, if you decide the prosecution has met this burden of proof, then the prosecution has proved the defendant was not insane at the time of the commission of the acts. In that event, your verdicts concerning the charges of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence must depend upon your determination whether the prosecution has met its burden of proof with respect to the remaining elements of this offense. Instruction 22. Concerning the affirmative defense of insanity, certain words or phrases have a particular meaning. Diseased or defective mind does not refer to an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Mental disease or defect means only those severely abnormal mental conditions which grossly and demonstrably impair a person's perception or understanding of reality, and which are not attributable to the voluntary ingestion of alcohol or any other psychopathic substance, except that it does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Moral obliquity refers to an act committed by a person who is capable of distinguishing moral right from moral wrong, but nevertheless acts out a perverse and culpable rejection of prevailing moral standards. Moral obliquity does not include an act committed by a person in a state of mental illness that renders the person incapable of distinguishing right from wrong with respect to the act. Incapable of distinguishing right from wrong refers to cognitive inability due to a mental disease or defect to distinguish right from wrong as measured by a societal standard or morality, even though the person may be aware that the conduct in question is criminal. The phrase incapable of distinguishing right from wrong does not refer to a purely personal and subjective standard of morality. If you find that the defendant, and this question will make more sense once you see the verdict forms. If you find the defendant guilty of one or more of the following charges of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence, you should disregard the remainder of this instruction and sign Section A of the verdict form for that charge to indicate your verdict of guilty. If, however, I think that's a typo. I think that's supposed to be B. We'll get to it in just a moment. If, however, you find the defendant not guilty of one or more of the following charges of murder in the first degree, murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence, you should sign Section A of the verdict form to indicate your verdict of not guilty, and you should also answer the following verdict question in Section B of the verdict form. Did you find the defendant not guilty solely based on the defense of insanity? Answer yes or no. The court reminds you that the prosecution has the burden to prove beyond a reasonable doubt each element of the crime charged, including that the defendant was not insane at the time of the commission of the act. If you decide that the only element of the crime charge that the prosecution failed to prove beyond a reasonable doubt is that the defendant was sane at the time of the commission of the act, you should mark yes in the appropriate place in Section B of the verdict form and have the foreperson sign the designated form in that section of the verdict form. If you decide that the prosecution has failed to prove any other element beyond a reasonable doubt, you should mark no in the appropriate place in Section B of the verdict form and have the foreperson sign the designated line in that section of the verdict form. In any trial or hearing in which the mental condition or of the defendant is at issue, witnesses not specially trained in psychiatry or psychology may testify as to their observation of the defendant's actions and conduct, and as to conversations which they have had with her bearing upon her mental condition, and they shall be permitted to give their opinions or conclusions concerning the mental condition of the defendant. This is an information instruction and must have no persuasive bearing on the verdicts you arrive at under the evidence. If a defendant is found not guilty by reason of insanity, it is the court's duty to commit the defendant to the Department of Human Services until such time as the court determines that the defendant no longer requires hospitalization because she no longer suffers from a mental disease or defect which is likely to cause her to be dangerous to herself, to others, or to the community in the reasonably foreseeable future. If a defendant is found not guilty by reason of insanity, she will never again be tried on the merits of the criminal charges filed against her. The question of the defendant's sanity or insanity has reference to her mental condition at the time of the alleged acts, the condition of the defendant's mind previous to the act charged, and since that time, may be considered only to aid you in determining her sanity or insanity at the time of the acts charged. In a few moments, the bailiff will escort you to the jury room, where you will select one of your members to be the foreperson. Your foreperson will preside over your deliberations and shall sign any verdict form and verdict question form that you may agree on, according to the rules that I'm about to explain. The verdict for each charge must represent the considered judgment of each juror, and it must be unanimous. In other words, all of you must agree to all parts of it. This requirement applies to any determinations that you make in response to verdict questions which you conclude should be answered. Only one verdict shall be returned signed for each count. The verdict forms, verdict question forms, and these instructions shall remain in the possession of your foreperson until I ask for them in open court. Upon reaching a verdict, and if required by your verdicts, answering any verdict questions, you will inform the bailiff, who in turn will notify me, and you will remain in the jury room until I call you into the courtroom. You will be provided with 4 verdict forms. You will also be provided with 4 verdict question forms with directions that explain under what circumstances you should complete those forms. When you have unanimously agreed upon your verdicts, you will select the option on each form which reflects your verdict, and the foreperson will sign the verdict form as I have stated. Similarly, if you conclude the verdict question should be answered, you will select the option on each verdict question form which reflects your unanimous decision, and the foreperson will sign each verdict question form as I have stated. I will now read to you the verdict and the verdict question forms. You must not draw any inferences based on the order in which I read them. The verdict and verdict question forms you will receive read as follows. Jury verdict count number 1, charge of murder in the first degree after deliberation. Part A, section Roman numeral 1. We, the jury, find the defendant, Letecia Stauch, not guilty of count number 1, murder in the first degree after deliberation. Part A, section Roman numeral 2. We, the jury, find the defendant, Letecia Stauch, guilty of count number 1, murder in the first degree after deliberation. If you fill out Part A, Roman numeral 1, you are finding the defendant not guilty, and you are finding the issues in favor of the defendant. If you do that, you need to fill out Part B, which asks you the question, if you find the defendant not guilty of murder in the first degree, you should answer the following question. However, if you find the defendant guilty of murder in the first degree, you should leave this section blank. As to the charge of murder in the first degree after deliberation, did you find the defendant not guilty solely based on the defense of insanity? So with respect to each verdict form, you have 3 options. It can be a straight not guilty, it can be guilty, it can be not guilty by reason of insanity. So if you were to find the defendant just straight not guilty, the prosecution had not presented enough evidence to establish beyond a reasonable doubt that charge against the defendant, you would fill it not guilty and be done. If you were to find the defendant or that the prosecution had presented sufficient evidence to prove beyond a reasonable doubt that she was guilty, you could fill it out as guilty. If you find her to be not guilty because she was insane at the time, you need to answer not guilty and answer this question on the back. Verdict form number 2, charge of murder in the first degree, child under 12, position of trust. Section Roman numeral 1, we the jury find the defendant Letecia Stauch not guilty of count number 2, murder in the first degree, child under 12, position of trust. Section Roman numeral 2, we the jury find the defendant Letecia Stauch guilty of count number 2, murder in the first degree, child under 12, position of trust. Again, only if you find her not guilty should you consider the question on Part B. As to the charge of murder in the first degree, child under 12, position of trust, did you find the defendant not guilty solely based on the defense of insanity? Verdict form or count number 3, we the jury, Part A, Roman numeral 1, we the jury find the defendant Letecia Stauch not guilty of count number 3, tampering with a deceased human body. Roman numeral 2, we the jury find the defendant Letecia Stauch guilty of count number 3, tampering with a deceased human body. And the same question on the back under Part B. Jury verdict form count number 4, charge of tampering with physical evidence. We, the jury, find the defendant, Letecia Stauch, not guilty of count number 4, tampering with physical evidence, or Roman numeral 2. We, the jury, find the defendant, Letecia Stauch, guilty of count number 4, tampering with physical evidence, and the same question on part B. So let me go back for a moment, double check this. Section A. All right, let me call your attention back because I may have introduced some confusion. If you look back at instruction 23, and I said I thought this might be a typographical error, it is not. That is an accurate statement. If you find the defendant guilty of one or more of the following charges of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence, you should disregard the remainder of this instruction and sign section A of the verdict form for that charge to indicate your verdict of guilty. That's an accurate statement. What I was thinking about is that it also implicated the insanity provision. But under section A of each verdict form, you're determining whether she's not guilty or whether she's guilty. So instruction 23 is accurate the way that it was stated and the way that it was read to you. I just didn't want there to be any confusion about that, since I may have introduced some. So what we're going to do is take about a 15-minute recess. So if I can have everyone back in the jury room at, say, 5 after 10, we should be able to start on time. Again, even though you've gotten the instructions, still can't start deliberating yet. You have to wait. So don't talk to each other about it. Don't talk to anyone else about it. Don't do your own independent research about any aspect of the case. We'll see you at 10 after 5 when we come back. My hope is, at this point in time, we will start with the prosecution's closing argument. Prosecution?
Thanks, Judge. Morning. Been on trial. You guys have sat through a lot of evidence, and you're going to have to sift through that evidence and sift through the instructions, kind of what we talked about when we're selecting you, and apply the facts of this case to the law that you now have been given. Before I start my closing, I want to just say thank you for that. You guys have been very attentive. I can see that every day. You've asked some very good questions that I'm actually going to use in my closing argument as I go forward here. One of the things about a homicide case that is true and to form in pretty much every homicide case I've done in my career is the case kind of devolves to talk about the defendant. We spend a lot of time talking about the defendant. And then when you add that the defense is insanity, you even spend more time talking about the defendant. I want to come back to Gannon in a little bit. Gannon's been in a box back here for the whole trial. This is what the trial should be about. And I'm not doing this to get sympathy from you. I'm doing this to tell you that what Gannon had to tell you in this trial through the autopsy, all you need to know, that when the defendant did what she did to him, saying at the time she did it, not only do we know how he was killed and the effort and determination it took to kill him, we also know that his body was found in Florida. Body wasn't found in Florida. Do you think we'd be talking about insanity in this trial? It's a pure fact of divine intervention that Macon Ponder happened to be searching that bridge when he did. Remember, he said he searched that bridge every 2 years. Just so happened on March 17th, 2020, out there searching that bridge and he saw that suitcase. Dr. Lewis says it was crazy to drive a suitcase across the country and dump it over a bridge in Florida. Was it really? Think about the divine intervention of Gannon's body even being found to get here to where we're at right now, and the effort and determination that she took to hide his body. We're going to talk about that quite a bit more as I go through my closing. What I'd like to do now is talk about the autopsy and his injuries. I'm not going to show you any pictures. I'm going to tell you that right up front. I'm going to use the diagram. I wonder if we can have the TVs turned on. Start with that. To describe his injuries, because his injuries are relevant. They're not only relevant to the crimes that she's charged with, the murder counts, but they're relevant to what her state of mind was when she committed those crimes. And so what we have up on board now is People's Exhibit 144. You heard Dr. Ignacio testify. We showed you pictures of each and every injury that Gannon had to his body. This first diagram in People's Exhibit 144 kind of depicts the stab wounds. It also depicts the gunshot wound to his left chin area. Now, at least the group that I talked to in jury selection, we talked about every day of your life, you were trained to be jurors. That means you're using your common sense to make decisions, just like you're going to have to today when you go back to the deliberation room. Just by looking at these injuries, what does your common sense tell you? Without Dr. Ignacio's testimony, Gannon was defending himself. He was fighting off, despite having hydrocodone in his system. Made him lethargic. He somehow was able to fight her off. The injuries to his fingers, the injuries to his arms. 18 times. 18 times she took a knife. Stabbed him. The locations of the stab wounds. What does that tell you? Use your common sense. It's not psychotic. It's strategic. The stab wounds are to the chest. As Gannon's fighting, the stab wounds are to his back. But it's not just stab wounds. You know that. He has to use judgment and reflection to get another weapon. What that weapon was, who knows? But she got a weapon and hit him in the skull 4 separate times. Go to the next diagram. I forgot to mention the strategic stab wound to his neck just underneath his ear, which we see in People's Exhibit 145. The diagram doesn't do justice to the skull fracture that she caused in him. And I'm not going to show you pictures, but I think, remember those pictures? Completely obliterated the skull. The amount of force it takes to do that, judgment, reflection. The next exhibit shows the injuries that he had to the top of his head. 4 separate strikes to his head. Wasn't good enough. Wasn't good enough for her. So, judgment, reflection, she goes and gets a handgun. She fires that handgun 3 times. I don't know how those bullets stayed in the pillow. We can rack our brain for ages. I don't know how those bullets stayed in that pillow. I don't know that we'll ever know how those bullets stayed in that pillow. What matters is the bullet that went into Gannon. That bullet matched the gun really she used that was still in the house. He attributed to Quincy Brown using, or Eduardo using, or whatever story of the day it was. Judgment, reflection, location of the gunshot wound. Let's talk about making ponder a little bit. Because as she drives to Florida, she checks in at about 12:22 in the morning, just after midnight, Candlewood Suites, Pensacola, Florida. Why do they drive all the way from Decatur in one night to get to Florida? Why does she want to get rid of Gannon's body in Florida? Gulf of Mexico. You drive this bridge at night, as Macon Ponder testified to, there's no lights on it. We know that sometime between, well, probably between 4 in the morning to 5 in the morning, she's out there. Look at the location where the body was found with the red arrow on People's Exhibit 63. More importantly, look at the space that she has to park this vehicle. I don't know where the pointer is, but you
Right
can see.
behind you. It's right there on the window.
Okay, thanks. You can see the shoulder here, and there's plenty of room. Why does she park there? Because she can. 4 in the morning, there's no traffic out there. Does she think there's water underneath the bridge? Is that illogical thinking as you're crossing the bridge and you can't see anything? You cross a main waterway, the Escambia River, and you continue going until you find a place to stop. She probably had to wait that there was no traffic. Gets rid of the body. Did she ever think the body was going to be found again? Go to the next slide. You see the suitcase underneath the bridge. And as Macon Ponder testified, it was where he and his coworker found it. It was clearly someone who dropped it directly over the bridge. There was an imprint that you remember seeing pictures of, and they ended up dragging it under the bridge, not knowing what the contents were. More importantly, not smelling anything. Why is that important? Charlie didn't smell anything. The body had been out here since February 4th. This is now March 17th in the Florida heat. They didn't smell anything until the suitcase was open. That lends some credibility to Harley when she says she never smelled or never knew the suitcase was back in the back of the van. Anyway, they dump it out and they see probably the most horrific thing anybody can ever see in their lives: Gannon's body in a fetal position, decomposed, wearing the same clothes that he was wearing January 7th, 2020. She killed him. Pants in a white stripe. Watch the video when they leave. See him wearing sweatpants with a white stripe. Talk about that more later. Now let's talk about the law, okay? And as I go through the law, I'm going to later kind of go through the timeline of events, and I would like you to think about the mental states and sanity as I talk about those. So I want to talk about the law first. The first instruction I have up here is the elements of the crime of murder in the first degree after deliberation. You will see that most of these elements are not in dispute. That the defendant, not in dispute. In the state of Colorado, at or about the date and place charged, not in dispute. After deliberation and with intent, those are highlighted because those are the culpable mental states that are attached to that crime. Those are the culpable mental states in the insanity definition that we're talking about. So I want to highlight those in a second. To cause the death of a person other than herself, cause the death of a person Gannon. Those are not in dispute either. Now, number 7 is the issue in the case. That's the insanity defense. I'm going to talk about in a minute. We can go to the next elements. After deliberation, not only intentionally, but also that the decision to commit the act has been made after the exercise of reflection and judgment concerning the act. An act committed after deliberation is never one which has been committed in a hasty or impulsive manner. Now, some of you, before you came into court, if you've never seen this definition, you're probably thinking about premeditation, where people are planning something out and it takes days to plan out the murder and then they finally do the murder. That's not what that definition says. It's just enough time to have judgment and reflection, to make decisions, to go from grabbing a knife, to go to grabbing some blunt force object, to go to grabbing. Is she exercising judgment and reflection? And it doesn't have to be good judgment. It doesn't have to be bad judgment. It just has to be judgment. Is she making a decision? A person acts intentionally or with intent when her conscious objective is to cause a specific result prescribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. I don't want to bet money on it, but I bet you a lawyer wrote that definition. It just means with intent. What was their intent? Did she intend to kill Gannon when she did what she did to Gannon? I would suggest that that's not in dispute. We can now go to the next crime, which is murder in the first degree, a child under the age of 12, and the defendant was in a position of trust. Now, the reason why there's 2 counts of murder, there's only 1 victim, is because this is just another theory of first degree murder. There's several theories of first degree murder in the law. These are the 2 that are in front of you now, okay? And as you can see, the mental state is what's different, and the age of the victim. And then the defendant has to be in a possession of trust. That's not in dispute. She's stepmom. She's obviously acting as Gannon's parent at the time that she. But let's talk about what knowingly is, because that's the culpable mental state with this crime. Person acts knowingly or willfully with respect to conduct or to circumstance described by statute defining an offense when she is aware that her conduct is of such a nature or that such a circumstance exists. A person acts knowingly or willfully with respect to a result of her conduct when she is aware that her conduct is practically certain to cause the result. Stab someone 18 times, hit him over the head 4 times. When you shoot at him 3 times, striking him once, I think you might have an idea of what the result might be. I would suggest that that's not in dispute in this case. So let's go to insanity. These words mean a lot. This is not something that you're going to find in the DSM-5. This is not a mental illness. This is a legal definition. These are just like the elements of the crime that we just went through. The reason I say that is because, first of all, I'm going to start at the bottom. It says the law presumes everyone to be sane. There's a presumption of sanity. However, after some evidence of insanity has been presented, the burden of proof shifts to us, and we gladly accept it. Gladly accept it. Now, what does insanity mean? The defendant was insane at the time of the commission of the acts if He was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to the act. That's why you heard me ask that question so many times. Or she suffered from a condition of mind caused by a mental disease or defect that prevented her from forming a culpable mental state, the ones we just talked about, that is an essential element of a crime charge. And then the next paragraph means something. Because it says, but care should be taken not to confuse mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger. Passion growing out of anger. If you lose your temper, you don't get to claim insanity. Revenge, hatred, or other motives and kindred evil conditions, because when an act is induced by any of these causes, the person is accountable to the law. So you can't lose your temper and come in and say, I lost my temper, I wasn't myself. We're humans. We have emotions. The next part is what's critical. It says, in addition, disease or defective in mind is not referred to an abnormality manifested by only repeated criminal or otherwise antisocial conduct. We heard a little bit about antisocial personality disorder. Who hasn't been diagnosed with that? But that's the reason why someone who has antisocial personality disorder, they have fun killing people. They lie all the time. They manipulate all the time. They have no empathy. They have no sympathy. Those people don't get to come in and say, I was insane. Now, what does mental disease or defect mean? This is what the legal definition of mental disease or defect is. And I'm going to leave this up here for quite a while because I'm going to go through all the doctor's testimony here in a second. And I want you to look at that instruction as we talk about what they had to say. But first of all, it has to be a severe word means something. It has to be a severely abnormal mental condition that grossly and demonstrably impairs a person's perception of understanding of reality and that are not attributable to the voluntary ingestion of alcohol or drugs. Mental disease or defect does not include an abnormality manifested only by repeated criminal or other antisocial behavior. So let's talk about that. The word, grossly and demonstrably. You think Harley might notice if she had a grossly and demonstrably mental condition? You think she might have shared that with you? You think Al Stauch might have noticed when it says it has to be grossly and demonstrably? He's got to demonstrate it, right? It's not something you snap your fingers and then all of a sudden go into a different personality. What about a brother? Howard, think he might have noticed it? Let's talk about the doctors. I'm actually going to talk about Dr. Niederhauser first. Dr. Niederhauser was really the first doctor and all the doctors you heard from to see her. If you recall, she saw her on December 5th, December 13th, 30 minutes each time. Came in and remember the difference between a clinical evaluation and a forensic evaluation? Clinical evaluation. I rely on what the patient says. I rely just like if they came in and said, I've got a fever, I'm going to take that at their word and I'm going to treat them for what they're telling me. She comes in and says, I've got anxiety. Treats her for anxiety. She diagnoses her with general anxiety. And she told you to understand that she had general anxiety at the time she's testimony. A lot of people did that came in and testified. That's not a severe and abnormal mental condition that grossly and demonstrably impairs a person's perception or understanding of reality. We all experience that. In fact, you got to experience her experiencing it on video. In January 29th, 2020, when she's being interviewed, remember at the end of the interview, she had to call the paramedics and she said she was suffering from panic attacks. The paramedics came in and said, your vital signs are not only good, they're exceptionally good. You're breathing fine. Your heart rate's fine. I don't know what the problem is. I think she might have been faking that to get out of the setting. Dr. Niederhauser also tells us that she had no history of inpatient psychiatric treatment, no history other than anxiety of any other diagnosis for mental illnesses. And this is based on what the defendant's telling her. No evidence of psychosis. No reason to put her on an M1 hold. If she was experiencing psychosis in December of 2019, the doctor would have had an obligation to commit her. That's the kind of stuff that talks about severely abnormal mental conditions. affects your vision of reality. It's not there. The other thing about that visit, the timing of that visit, December of 2019. Remember, the whole purpose of that visit is so that she can get a letter to go to her employment because she didn't want to work anymore. The ironic part about it is at the second interview, the defendant tells her, I don't want to work there anymore, but I got a contract, so I need a letter to get out of it. But what else happens right before Gannon is murdered? Goes on a cruise. Goes on a cruise in January. You think that might have something to do with not wanting to go to work based on what you know about her and the statements she's made? Dr. Moore, Christine Moore, she works at the jail. She's a psychologist. She evaluates people who come in who are charged with serious crimes, perhaps their first time in a jail. They evaluate to see if they're a danger to themselves or others. It's a psychological evaluation. She said it was a clinical evaluation. They also want to know if there's any medication they might need. What the defendant tells her is that she has anxiety. I didn't do the crime, not going to be a problem. That was on March 5th, 2020, first day of her visit in the jail. Dr. Moore spent quite a bit of time with her up until January 5th of 2021, seeing her either once every 2 weeks or once every week, depending on what was going on with her. March 20th, she goes to her and says, I just want to see how you're doing. And his body was found. Never in Florida. The reason why I'm telling you this is because she doesn't say, hey, Maria Sanchez did it. Or, you know what? I got dissociative identity disorder. You're a psychologist. I need help. Nothing. In fact, she told you there was no evidence during the entire time she spent with her that she had dissociative identity disorder or any other severe mental illness that meets that definition. This was it was a little over a month after the crime, January 27th to March 5th. And then what happens on June 5th, 2020 in the jail? You recall Dr. Moore's testimony. She reviews all the deputies' notes to see what's going on with the defendant at the time, to see how she's doing. And she reviews notes from deputies that say, I'm going to start acting crazy. That's what the defendant says. And then on that very day, June 5th, 2020, she enters a competency issue into the court. That's how we get to the competency evaluations that I'm going to talk about here in a second. The timing of that. Okay, Gannon's body was found on March 17th. She finds out about it on March 20th. You know that she's read the discovery of the police reports in this case, and there's nothing wrong with that. She's entitled to read that. Point is, she's read it. And then all of a sudden, I'm going to start acting crazy. For another defense? No dissociative identity disorder, certainly no Maria Sanchez during her entire time or entire visits with Dr. Moore for that year period of time. The first competency evaluation was done down at the state hospital. We don't pick where she goes. The prosecution, when I say we don't pick what doctors do the evaluation. Court orders it, goes to the state hospital. Doctors are chosen, they do an evaluation. What's relevant about this first competency evaluation that takes place on July 20th, 2020 is when she goes to the state hospital, is that they have a 2-week observation period. Her nurses, employees are watching her. He actually goes to a nurse and says, can you tell when someone's faking it? Dr. Torres and Dr. Gray actually, they do a forensic interview with her on August 4th of 2020. Again, now we're in a forensic mode. Now we're not just going to listen to what she has to say. We're going to look at collateral information. We're going to call Al Stauch. We're going to try to call Harley. We're going to try to call family members to see if we can corroborate what she's telling us. So what is she telling? I've got bipolar disorder. I'm a manic depressant. I ramble. I'm a manic depression. That's my mental illness. Nothing about dissociative identity disorder, which according to Dr. Lewis, she's had it since a very young age. Nothing about Maria Sanchez. Remember Dr. Torres' testimony? when she was talking about the competency evaluation, one of the psychological tests that she took had a question about multi-personalities. And the answer led Dr. Torres to ask her, hey, do you have multiple personalities? This is August 4th, 2020. Dr. Gray and Dr. Torres diagnosed her with specified personality disorder with borderline and narcissistic features. Talked about that a little bit. Now, does it meet that definition? How do we know if it meets that definition? Her actions, how other people perceive her. Also, Dr. Torres said you, no, it's not a severe mental disease. It's not something that affects her everyday life, that affects her ability to make decisions. No evidence of psychosis during that evaluation either. No history of inpatient treatment during that evaluation. Psychological testing. MMPI-2. Remember that test? What does that test tell you and told Dr. Torres and Dr. Gray? That she exaggerates psychiatric symptoms to the point where even people who are hospitalized for their mental illness don't answer questions that way. You think she might be faking it? Now we go to the second competency evaluation with Dr. Grimmett. Now, remember how Dr. Grimmett became involved in this case? The defense at the time, and it wasn't these defense attorneys, requested that she do the evaluation of the second competency evaluation. We had nothing to do with that. So now this happens on December 22nd, 2020. That's when Dr. Grimmett talks to her. And so I want you to think about how it's progressed now. Now she starts talking about dissociative identity disorder and bipolar disorder. When I say she, the defendant. That's what the defendant is telling Dr. Grimmett. She says she has 4 distinct personalities. None of those 4 were Maria Sanchez. Remember what Dr. Grimmett testified to? That she was, first of all, creating these names. Second of all, like Jasmine was a Disney character. Talked about vampires. Twilight. I've seen the movie Twilight. I know I hate admitting that, but I've seen it. And she cited the characters from that movie. And Dr. Grimmett said, wait a minute here. You're just telling me characters from a movie? That's not dissociative identity disorder. But she evaluated her for it because that's what she's telling. Dr. Grimmett evaluated her for DID. Said, no, not there. I don't even need any more information. I don't need to rule it out. Not there. She also diagnosed the defendant with other specified personality disorder with borderline and narcissistic features. She also told you that it doesn't fit that definition. Jump forward to February of 2022. I don't know when the conversation took place, but at some point before the defendant pled not guilty by reason of insanity on February 11th, 2022, they had a conversation, the counsel had a conversation with Dr. Lewis. Remember Dr. Lewis testified that I recommended you change your plea to not guilty by reason of insanity. Why is that important? Why did I ask her about that? I think that put a little pressure on her. And she says, I recommend you plead not guilty by reason of insanity, and I'll do the evaluation. Why didn't she do the evaluation right away? Why'd she wait till November? Come out and talk to the defendant. Needless to say, when she pled not guilty by reason of insanity in February, the same process happened as happened when she raised competency. Sent down to the state hospital. The state hospital chooses who's going to do the evaluation. They make a decision on who already knows the case. Dr. Torres and Dr. Gray already read all the discovery in this case. They knew the facts of the case. They knew the defendant, but they're doing a different evaluation. As you remember, competency goes to her state of mind at the time they're doing the evaluation. What's her understanding, what's happening in the courtroom, whether or not she can get along with her attorneys, that kind of thing. Insanity is completely different. Insanity, you got to go back, just like the law says, at the time of the crime, what was her mental state? So that's a much broader evaluation. You got to look at everything. So Dr. Torres and Dr. Gray, they also reach out again, call out. They attempt to talk to Harley, family members, to see what's going on with her. But what is the defendant saying now? Done off of bipolar now. And now she's created more personalities as part of this dissociative identity disorder. Is it just a coincidence that she's consulted with Dr. Lewis prior to all this. Now Maria Sanchez comes into play during this evaluation. Dr. Torres testified, and it's in a report, that she said, there is no credible evidence to conclude she has a condition that conforms to the definition of a mental disease or defect. Pretty powerful language. That's powerful language. No credible evidence. What's also interesting about this evaluation compared to Dr. Lewis's evaluation is they do two interviews, if you remember. One was in March, one was in June. The March interview, I think I couldn't count how many questions, but it wasn't a lot of questions asked. It was the defendant talking. They just let her go. In June, they asked more questions. One of the questions that Dr. Torres asked is, can we talk to Maria? Can we talk to Maria Sanchez? She said, no, Maria just doesn't come out. There's got to be some kind of stressor. There's got to be a triggering event, which coincidentally is exactly what the DSM-5 says. I can't just summon Maria. You saw on Wednesday how that happened. It was magic, according to Dr. Lewis. No severe abnormal mental conditions that grossly and demonstrably impair a person's perception of understanding of reality. No psychosis. No bipolar. Because remember the first competency evaluation, they said they had to rule it out. They've ruled it out. Bipolar does not exist with this defendant based on Dr. Torres and Dr. Gray. They also said no dissociative identity disorder. Didn't have to rule that out. They had enough to say there's no credible evidence. That's not there. They continued on with the diagnosis of other specified personality disorder with borderline and narcissistic features. Dr. Torres and Dr. Gray came to the conclusion that the defendant was not legally insane at the time of the crime. Let's go to the next slide, which is the credibility instruction. This instruction applies to experts as well. You may believe all the testimony of a witness, part of it, or none of it. This instruction applies to every witness who testifies, including Dr. Lewis. I got highlighted certain words there. Motive. Didn't see motive in the elements of first-degree murder, but you see it here. Money is a strong motivator. Having shows on HBO, strong motivator. Having your son videotape evaluations on a first-degree murder case that's gotten quite a bit of publicity for perhaps another documentary is motive. You're gonna do a documentary, she says, she's sane, sorry, did what I could. Acting. Not as good as, well, not as bad as Robert De Niro, I guess she would say, but she's acting. You also have to look at her demeanor and manner while testifying. She wouldn't answer any of my questions. She wouldn't answer my questions because she didn't want you to know the answers. She wanted you to know what she wanted to say. She shows up to court late. Talk about narcissistic tendencies. Manner while testifying. I think it speaks for itself, how she testified. Especially when you compare Dr. Torres. Obviously she would disagree with my questions. Every many times she says it depends to me. She's not our expert. This happens to be the expert that the state hospital chose to come in to do a neutral evaluation, the truth. Dr. Lewis. She didn't know the legal definition of insanity in the state of Colorado, ladies and gentlemen. The whole reason she came in to testify. I'm not even sure what her opinion is anymore, based on your questions at the end. Remember how she answered it? About the MRI and the EEG that she withdrew? My opinion is ongoing. What does that mean? Does that tell you that her opinion that she was legally insane at the time counts for anything? Because when you think about her report, she does this preliminary report, which was supposed to be an insanity report, 35 days before trial, that says, hey, I need more information. I need an EEG and an MRI done if I'm going to make a decision on insanity. Well, that doesn't happen. MRIs, you take someone to the hospital for 2 hours, you do an MRI, you come back. Never happened. But yet, few days before trial, she hands over a report saying, I find her legally insane. And that's literally all she says. Don't know what standard of insanity she's using. But I do know that she didn't get the information that she needed. But you know what information she had? She had a third MMPI 2 test that Dr. Torres told you about, that a Dr. Leach took, that was hired by the defense to do psychological testing based on what Dr. Lewis requested. Guess what the results of that showed? It was the same, exaggerating psychiatric symptoms to the point where people who are hospitalized for mental illnesses would not answer those questions that way. That didn't seem to matter. I want to talk about the facts of the case, and the reason why I want to do that is because I think it's important for you to look at the defendant's actions before, during, and after she killed. I'm going to start with the video of Gannon's burns. Just get both of them. Yeah.
I just don't know what to do.
Well, devastating. Initially, Scott can't lie when the TMZ information.
Gannon, I promise this is the last time I'm going to ask you. I'm just freaked out, okay? Are you sure you didn't do it on purpose? Okay, we promise. You promise. Pinky promise. Okay, all right, so listen. We're going to have to sell stuff to fix it, okay? So we figure out what we got to sell. We can sell the sofa. We can sell whatever, because we got to get it fixed. So lady, don't be mad at us and kick us out the house, okay? You got it? You got it?
I'm just worried about my.
Okay, shh, listen. So tomorrow.
Why is that important? Why is she videotaping an 11-year-old boy who has burns? More importantly, why did she stop videotaping a little boy? Gannon. It might be because Gannon said, I'm just worried about my burns. I think that was the purpose of that video. I think that's using judgment and reflection. Now, the hydrocodone. I can't stand here and tell you how that got into Gannon's system. All I can tell you is there's only one person there that could. Did she give it to him because of the burns? I don't know. But when she gave it to him, do you think that's using judgment and reflection? January 27th. This is actually at 9:46 is when this video was recorded, Monday night. The next morning, January 27th, 2020, at 4:36 in the morning, decision was made for her, or she made the decision to text Miss Hicks saying, my stepfather had just been killed in a car accident, or words to that effect. Ms. Hicks responds later on saying, I'm sorry, please let me know. And I'm paraphrasing, I don't have it memorized. But she says, words to the effect, please let me know if there's anything we can do and when you can come in. She responds back, the defendant does, by saying, why are you being so insensitive? This is a family member that just died on the East Coast. Why is that important? Because that's the theory that Dr. Lewis wants you to believe. The fact that she makes this text about the stepfather is somehow tied to the killing of Gannon. Some years later. It just means she didn't want to go to work that day. Could it possibly mean that she knew what she was going to do when she said, and tomorrow? And shortly after that, she calls Gannon school, says, he's not coming in today. And she texts Al Stauch and says, hey, I'm going to make up an excuse, not go to work, what she does. And Gannon's not going to go to school because of his stomach issues. Judgment, reflection. Then on that same morning at 8:14 and 8:16 a.m., she takes that picture of Gannon in bed. Why did she take a picture of Gannon in bed in his bed and text it to Gannon's father, Al? Look, Gannon's alive. He's here. He's sick. He's in bed. You heard Al Stauch testify a little bit about Gannon. He has ADHD. Hyper. That's still at 8:14, 8:16. Think he might be lethargic from hydrocodone? Why he's still in bed? Think she wants to prove that he's still alive because she knew how much hydrocodone she gave him? Is that a rational reason to do it? Does that make sense? January 27th at 9:54 a.m. Text Al from her phone. This was your question, by the way. She texts Al from her phone saying, I left my phone at home before she left the house. You think that's an indication that she knew what was going to happen? Is it that far-fetched to think that she knows Gannon had been poisoned and that something might happen to Gannon? Then at 10:12 a.m., they leave in Al's truck. And again, this is the video that you saw that you can see his pants with a white stripe down him when they leave. You see him get into the back seat of the pickup truck, and Stauch gets into the driver's seat. They drive away. What the heck is she doing taking a sick kid out to go shopping for dog clothes? Narcissistic tendencies. Not me. Dogs. They're gone until 2:20 p.m. when they come back. You saw the videos. She drives in the back of the driveway. She's got to back in and then drive back in. Eventually, the truck comes to a stop. They're stopped in that driveway for 39 seconds. What are they talking about in that truck? Doors open. You see the leg drop. You see Gannon beeline right through the garage. You see the defendant going after. At 2:26 p.m., see the defendant come out and move the Tiguan from the driveway, back it into the garage. What was the need at that moment to back that Tiguan into the garage? Then you see her come out in the front of the garage, out in front, below the garage door, and look around, back in the house. This is when the murder happens, ladies and gentlemen. 30, right in that time frame. There's no activity on her phone. And does autopsy. Hacks him with a knife. Good enough. And he fought when he was born. He's fighting now. On 1 pound, 6 ounces. Get it through that. Coming after him. Goes to get a blunt force object. Crush his skull. Not sound like rational thinking, but it's certainly thinking. That's the before and during. A lot to talk about. There's so much to talk about after. She stuffs him in a suitcase. She drags his body to the storage room, opens a large green suitcase, somehow manages to squeeze him in there, gets the blankets off the bed, wraps him up in that, pillows, picks up the shell casings, does something with a knife, does something with a blunt force object. She sticks him into the storage room and throws boxes on him. At 3:11 p.m., Al texts her, said, "Are you sleeping?" No response from the defendant. Lena gets home. She gets to the house about 3:15 p.m. The bus comes by about 3:11 p.m. Doesn't let Lena in the house. She makes Lena stay outside because she's got work to do. Got to clean that bloody mess in that room. Got to hide evidence. Got to tamper with things. Gannon's dad texted him at 3:35. Said, "Hey, buddy." Having no clue what she did to him. No response to that. No one read that text until 7:40 that evening. That was the defendant reading it. 6:27 p.m., the defendant texts Al and says, "Gannon went to a friend's house. He's supposed to be home at 6. He's not home yet." 6:55, she calls 911. You heard that call. How can she do this? How can she talk to Gannon's father like nothing happened? That traits of an antisocial personality disorder, the fact that you can have no sympathy, so cold and callous, and act like nothing happened, and she does it through the whole day. You guys know that. She calls Landon on Gannon's phone a couple times that night. Is that a trait, an antisocial personality disorder? Landon gets a call from Gannon. She knows he's missing, and it's her. Next morning, January 28, 2020, at 6:22 a.m., you see the T-Bone leave. It's gone for 10 minutes. What is she doing? Is it beyond the realm of possibility that she's doing a practice run to see if anybody's watching her? She's about to move the body. Is that beyond the realm of common sense? She again comes back, backs into the garage. Heard evidence that she'd never backed that T1 in the back of the garage until that day. They leave. When I say they, Bandit and Gannon's body. Go to the airport. Leave the house at 8:13 a.m. They get to the airport about 8:30 a.m. She's made the decision to rent another car. She even left the house. Is that evidence of psychosis? Or is that evidence of thinking things through? I'm going to leave Gannon's body in the back of that T1 at the airport. We're going to pick up a car. Al's didn't care because we don't want to put mileage on my leased vehicle. Al gets off the airplane. He's just worried about Gannon. Where's my son? You think at that moment he cared that she rented a car? But she made a big deal about, hey, I don't want to put miles on my T1. She never searched for Gannon. They go to the interview at Starbucks at approximately 1:30 that afternoon. They have that interview, you heard it. After that interview, she disappears. She takes the rental car and it's gone. No one knows where she's at. We do. Is that Life 360 app? We got her going back to the airport at 4:41 p.m. We have a parking ticket that was found inside the white Kia rental car that says she went into the airport at 4:41 p.m. Now, she must have got out of there quickly because she never had to get another ticket when she left. But we know from Life 360, and we know from the telematics on the Tiguan that the Tiguan didn't leave, that she leaves the airport shortly after that. What is she doing at the airport? Is it that crazy to think that she's checking on Gannon's body in the back of the Tiguan? That sound like someone doesn't know right from wrong? That sound like someone who's trying to get away with something. At some point that afternoon, as Al Stauch is out looking for his son, he goes to French elementary school. And he goes there because his wife, the defendant, says, I left the Tiguan there. That's a critical moment in the investigation because when he sees the Tiguan is not there, he now knows that his wife had something to do with the disappearance of Gannon. And the investigation starts to look at her. Because he has a second interview that night, he tells the police, I didn't think much about that rental car until I went to French Elementary and I didn't see the Tiguan there like she told me it was. At 5:25 p.m. that night on the 28th, she tells Al Stauch, you need to get an attorney. 7 p.m., she returns back to the airport. She parks that white Kia in short-term parking, keeps the keys, and drives off in the Tiguan and exits the airport at 7:03 p.m., very close to that time. Got the ticket. You've got the ticket. We got the telematics and know exactly where she goes. Got the text messages between her and Harley. Which clearly show that she's manipulating Harley, her own daughter. Don't let the police in. Don't talk to the police. The pizza guy? All right, you can let the pizza guy in. If she's manipulating Harley, do you think she's manipulating Gannon? Do you think she's manipulating Lena? Do you think that's manipulation, the video you just saw? We're going to have to sell stuff because the lady's going to be upset with us, the owner of the house. Goes to the S-curve in Palmer Lake. You know that at 9:23 p.m. She's there for at least 5 minutes. We don't know how actually she's there. We know that the board was found there sometime in mid-February when we started searching there based on the information we had from our Life 360 and the telematics. We know that board had Gannon's blood on it. DNA matched it. Why is she going out to hide the body there? I don't know. Probably because it's a good location. She can't keep it in the Tiguan. She know right from wrong? At 12 a.m., 28th into the 29th, Harley drives out to her employment to pick her up. They leave the Tiguan there overnight. This whole time while she's missing and dumping Dan's body up in Palmer Lake, Detective Bethel's trying to get her to come in for an interview. Remember that? Gannon Stauch's trying to call her to get in for an interview. Her phone's on airplane. The next morning, Harley drives her to the airport. They drop off the keys to the Kia. When I say drop it off, they threw the keys to the Kia to an attendant, left. Is that rational thinking? Is that someone who didn't want to get caught? Text at 10:25 a.m. on the 29th. I'm on my way to Detective Bethel. The interview. Takes her over an hour and a half to get there. We know that the car is washed on the way. You saw photos of the water dripping off of it when she gets there. The interview she gives, you watched it. I'm not going to get into all the details. I just want to emphasize that she plants seeds. The suitcase is critical. Who says that? I think it was Eduardo at this time. Eduardo also took a suitcase when he took Gannon. She knows where the suitcase is at up in Palmer Lake. On January 30th, 2020, her family shows up. Dakota Lowry, Brenda Awkward, and Deborah Locklear, her mother. Flying to Denver, they rent that Nissan Altima and drive down Colorado Springs. They pick them up, take them to the Extended Stay Suites Hotel. The next morning, they rent that van, Brenda Awkward does, to collect their stuff at the house. They get her suitcase, including that red or pink suitcase that we recover in South Carolina that has blood on it that happens to match Gannon, with a blanket inside it that happens to match Gannon. Pretty strong evidence. You got blood of the victim that you just killed with you when you're arrested on March 2nd. But what happens after they load things up? We know the suitcase was not there because the police were checking everything that came out of that house. We also know what Dakota said about when they exchanged vans, that he saw that very same green suitcase that was under the bridge that day, and she says she had softball equipment in it. But when she gives the interview with the KKTV reporter at 12:10 p.m., well, let's just look at her words. What are her words? We can play this video.
You are.
I am Letecia Stauch, which is Gannon's stepmother.
You've been a part of the investigation since the very first time. You were the last person to see him. Is that right?
Correct.
What did you see when you last saw him?
Well, I'm not allowed to talk about anything with the case. I would more so be willing to talk about how the community needs to have faith and continue to work together and not make these false accusations. And I would never, ever hurt this child. And I know there's some questions out there about, okay, so tell me what happens. That's up to the investigations when they end up letting you guys know. But I've cooperated with them, even to the point that we were held with a gun. And my daughter, a 17-year-old who serves our country in the United States Air Force, who has never committed a crime or done anything wrong in her life, was put in handcuffs over the keys that was in her purse so they could take her car. I'm just ready for Gannon to come home. Most importantly, for him to see his family. But second, I am going to be so ecstatic when I'm able to say to people that I hope they have a really sincere apology for all these theories that have came out online, for all the things they said that I have done or people have done. And I just want everyone to know that we're going to find Gannon.
Can you talk to me a little bit about him? I don't know it.
Gannon is so kind and he loves to play video games. That's one of his favorite things. He loves Sonic and Mario. And, you know, he's always helpful. And he was always so helpful with the dogs around the house. And we have 2 little cute dogs. And he was always like a person I could say, Gannon, can you go do this? And he would do it right away. You know, sometimes with kids, we have to remind them and things like that. And that's okay. But he was so sweet and able to help anyone. He could notice when you're sick and say, are you okay? And such a kind heart. We should all come together and wait until the end and see what happens because Gannon's going to come home.
Any message for Gannon?
The message for Gannon I have is, Gannon, when you get here, you'll be able to truly tell what happened. And then I really hope I get a sincere apology from everyone who has made all those things, especially from my husband.
What we just heard there, that evidence that she might have some antisocial trait. Calmly talk about that to a news reporter. She's done. I failed to mention Amanda Van Nest, who was the same nurse who examined her for injuries based on what she was telling people. First interview that she was raped and she examined her head and found no injuries. But what else did she do? She also told you about M1 holes, and if she would have noticed anything that would require her to have a doctor examine her for an M1 hole, she would have done it. No evidence of mental disease, no evidence of psychosis. And this is the 29th, 2 days after she killed him. We know that a GPS tracker was later placed on that Nissan Altima, and you know where she went when she disappeared for 2 hours and told her family that she was going to a pet store. Got her right back at the Isker. She picks up Gannon's body, puts him in the trunk of that Nissan Altima, leaves the board out there, later found, and drives back to the hotel after she goes and gets some more dog outfits. And when she gets back to the extended stay suites, she's got to move Gannon's body from the trunk to the van that Brenda Awkward rented earlier that day. We know that had to happen because of Dakota Lowry's testimony. Her and Dakota go to the budget rental van place the next morning, February 1st, and they've got to move all the suitcases from one van to another. That's when he sees the green suitcase, knew something was suspicious about it. You saw his reaction. Had to get on a witness stand. He got subpoenaed here to come here. I think he felt manipulated by this defendant. You know the rest of the story. She drives across country with Harley. She's using the Ford Motor Company to check in hotels. They've got a little scheme you saw in video. Harley would go in with the dogs. She'd check in as one person. All rational thinking. It's also by social personality traits, perhaps. They drive all the way to Florida. They get there February 4th. Another divine intervention. The power up at 4:36 in the morning in between the hotel and where Gannon's body is found. Every 24, 25 hours it happens. It happens at that moment. That tells you that van is on the move in the middle of the night. Tells you she dumped Gannon's body that night for the early morning hours of February 4th. I'm going to go through fast now because I've been talking way too long. I want to talk about the pretext phone calls. You know all the stories. I'm not going to get into the details. Eduardo, immunity, Quincy Brown, several different versions of that. Bike accident, Uncle Matt. One that significant, and she says, I'm so sorry, Al, for lying to you. I'm going to tell you the truth. I wasn't in the car when I left Petco. He wasn't in the truck. Fake pregnant lady with cash. She's laundering money. She's arrested on March 2nd, 2020. She comes up with a story of now how it's Angel, the babysitter, who did it. Suitcase with Gannon's blood found on her. We've got all the searches on her phone that I'm not going to go through. You just saw it a few days ago. But what I'd like to talk about is what people who are truly legally insane do under these circumstances. Because there are people who are truly legally insane, ladies and gentlemen. They don't act like that. If they don't have the capacity to know right from wrong, they're not going to hide the body. They're going to act like nothing happened. They may even do the crime if someone's there watching them because they don't know that it's wrong. Do you think she would have done this to Gannon if anyone was in the room with her? Of course not. They also don't lie. There's no reason to lie because they don't think it's wrong. So they come in and they say things like, my God, I heard a voice that I thought was the devil, and the devil made me do this. I had no choice. Why are you even talking to me about it? That's what we're talking about when we talk about a severe mental disease or defect. When we're talking about the capacity to form the intent or the capacity to use judgment and reflection, I'm going to refer you back to Mice and Men, the book. I read that a long time ago, but I still remember it. It's about George and Lenny during the Depression. And George is a smart one. Lenny has some severe mental illnesses. Lenny likes to pet rabbits. He's such a big guy that he doesn't even know his own strength. So he would pet rabbits to the point where he would kill them. That's what we're talking about when you don't have the capacity to form the intent to kill because the mental illness doesn't allow you to. We're not talking about someone who makes choices to get weapons to kill with. I appreciate your patience. I know I've talked a long time here, much longer than I thought, and I apologize for that. There's only one right verdict in this case. That's guilty to each and every charge that she's charged with. First-degree murder after deliberation, first-degree murder, child under the age of 12, tampering with a deceased body, and tampering with physical evidence.
Can we switch over? Yeah, they did. Oh, whoops, wrong one. Sorry, my bad. There you go. The one thing they cannot answer, because there is no answer, is motive. Motive for why this happened. Motive how we can go from this picture on a hike up at Garden of the Gods, loving, kind, to less than 24 hours later. Brutal rage, 18 stab wounds, 4 blunt force trauma, shot. This wasn't a pre-planned, calculated killing for some gain. This was a psychotic break fueled by rage, attacking a demon from the past. They cannot come up with a motive because there is no motive that makes sense, ladies and gentlemen. They have tried. They have spent hundreds, if not thousands of hours trying to come up with one. They've gone through phones. They have gone through iCloud accounts. They have gone through Facebook messages. They've interviewed everybody who they could possibly think of to try to find some motive. None of what they have done in this, the biggest investigation in the history of El Paso County, has come up with a motive. No one who they have ever interviewed has ever said that she ever had a problem with Gannon. No one who they have ever interviewed has ever said she was ever mean to Gannon. No one who they've ever interviewed or come across anything and said she's ever done anything wrong to Gannon until that horrible day when this happens. That is the evidence, and the most strong evidence to know this was not premeditated murder. This was a psychotic break. That is the only thing that makes sense. And when you can pull yourself back and peel back the layers of the anger over the act, at the anger over the deceit in which it happened, at the anger over Gannon's body being driven all the way to Florida, when we take those emotions back and we try to look at this rationally, the only thing that possibly makes sense is a psychotic break. There is no other rational explanation to understand why this happened other than that. He was a special needs teacher, elementary needs teacher. That's what she'd been her entire life, working with kids with special needs. She was a mother to Harley, did everything she possibly could for Harley. She was a wife to Al. She was tried to be the best stepmother she could be to these kids. So much so that she was left with the kids for very long periods of time. In the months preceding this, when Al had gone up to Alaska, he had left his 2 kids in her care. He was gone. We were about as far across the country as you could possibly get. And based upon his relationship with her, based upon him seeing her as a loving stepmom, felt comfortable leaving his children with her alone in South Carolina. And he did that because he knew her and he saw her and he saw that relationship she had with Gannon, and he felt comfortable based upon what he had seen with her. And he felt comfortable enough that when this was going on, he felt comfortable enough to leave to go to Oklahoma. Because what he had seen and what this photo shows is they had a loving relationship together until the evidence shows that she had a psychotic break. That something, mental illness from her past, got triggered, and there's a temporary period of psychosis. That's the only rational explanation that had been presented. And there's nothing else they can come up with as far as motive. Ladies and gentlemen, does it make sense that she may have Google searched maybe moving to Florida? Yeah. People have problems in marriages. Do people fantasize some about getting out by Googling stuff? But how would brutally murdering Gannon, how would stabbing him 18 different times facilitate that move? It wasn't. There's no rational basis behind the murder other than psychosis. The fact that she may have years before at some point in time done one Google search out of thousands saying, I don't like my stepson. That's not what I see there in that picture. That's not what I see there going on in the days leading up to this horrible tragedy. What it does seem to indicate, ladies and gentlemen, if we start looking at this time frame, looking at the reliable evidence that we have in front of us, is that somehow that fire set up some type of trigger. Maybe some type of trigger that had been disassociated long ago. But we have her starting meltdown right after this fire. Ladies and gentlemen, Dr. Lewis used the term wacky a lot, maybe not the most scientific term, but when something seems irrational, when something doesn't seem to make sense, we have to consider mental illness. We have to consider possible psychosis. I would say that video that you heard up there, listen to the tenor of her voice, listen to what she is saying.
She says, I'm freaked out. And when you listen to her voice, she is freaked out. And she's saying irrational stuff like, we're going to have to sell the sofa. Stuff like that to Gannon. That makes no sense there whatsoever. And then importantly, ladies and gentlemen, we also see mania starting to settle in when we start looking at these timelines specifically. Be up there, they're texting back and forth, 10:15, Harley comes home, 10:24, 11:30, she's still talking to Al. $2:48, she's texting Al. 4:36, texting the school saying that her stepfather passed away. Her stepfather who had abused her, who is not, and you heard it from Dr. Torres at the state hospital, they are not doubting or disputing the abuse that she suffered growing up. And that's from Dr. Torres, who had investigated this, who had medical records provided, who had family members provided, who interviewed other family members, and she says the state hospital is not disputing the horrible trauma that she grew up with. And the person who she had suffered that horrible trauma from, that's who she calls and says dies at 4:36 in the morning. What is more important by this, ladies and gentlemen, important to look at, what is also that we see, what is she not doing? She's not sleeping. She is manic at this point in time. She is texting throughout the night, 2:48, 4:36, 4:36 again, 5:03, 5:49, 7:32. She is up the entire night and not sleeping. There is something going on with her head that is not seeming right. There's stuff going on through the day. The text messages back and forth. Harley leaves for work. Other conversations are going on. And then they leave, they go up to Petco. Ladies and gentlemen, Mr. Young has tried to insinuate that all of this was some type of big preconceived plan, that she had made some decision earlier on at that point in time that she was going to kill Gannon. Ladies and gentlemen, does that make any sense? If she had decided at that point, early in the day, when everybody else leaves, Harley's left for work, she's just there alone with Gannon by herself. If there was a decision that was made that for some reason they cannot explain that she was going to brutally murder him, why is she taking him in the car and going up to Petco to buy Valentine's Day outfits for the dogs? That makes absolutely no sense why she would push back a timeline to just an hour or so before Lena got home, for some reason, unbeknownst to anybody, commit this brutally horrific act. Mr. Young tried to comment a lot about the hydrocodone. Be very careful when they try to put facts in their opinion or what they would like them to be that was not provided by any of the witness testimony. Dr. Ignacio testified that there was hydrocodone in the system. She never made any assertions about how much, whether it was a dangerous level, whether it was inappropriate, whether it would have been affecting him whatsoever that way. All she said is, this was a tox screen, this came back. That's Mr. Young's opinion that somehow this was an overdose of hydrocodone, but there was no evidence of that by their expert. And there is no basis that would be for a brutal, horrible attack on a young 11-year-old boy that she'd just been hiking with up there 24 hours earlier. Something is going on in her mind. Something is there losing it, and something horrible occurs in the basement where there is a brutal, brutal attack. The brutality of attack, ladies and gentlemen, I would say is the strongest evidence in this entire case of a psychotic break. That type of violence wouldn't be needed to kill an 11-year-old boy. Gannon weighed 80, 85 pounds, an 11-year-old kid. Not the biggest 11-year-old kid, not the strongest 11-year-old kid, fun, nice kid. What do we know about him? He likes to play a lot of video games, but not needing this type of brutal, horrific rage to kill him. And there is no other, again, explanation other than the psychotic break. Lena then comes home, and ladies and gentlemen, look on that video. Lena wasn't pushed outside. Lena came in the house. She's in that house for about 10, 15 minutes. And then she goes out and gets on her bike and leaves. The idea that Lena was never allowed in the house is a fantasy that is not supported by the evidence, that is not supported by any of the videos. Okay, that is Mr. Young's opinion. But look at that video. You see her going in the house. You then see about an hour later, Harley coming to the house. And we know that Harley came in the house, and Harley actually went down in the basement. Why do we know that? Because she changes out of her uniform before going to the dollar store. So there is nothing in there that these kids were kept out of this house, and there is nothing to indicate that this was pre-planned that would keep this type of information away from them. What is going on in her head? We don't know. But here's the important thing, and here's what Mr. Young is trying to do. He is trying to introduce antisocial personality disorder into this. Because I would state to you, ladies and gentlemen, there are only two things that account for her actions at this point in time for the remainder of this day and the days preceding is either disassociation, or she has put that memory of this brutal attack of what she did to Gannon someplace that she doesn't have access to, and she doesn't understand what's going on or where Gannon is, or what she had done to him, or antisocial personality, or that she's some type of psychopath. Mr. Young, remember back to Dr. Torres, tried to interject many times with Dr. Torres the possibility of antisocial personality disorder, and Dr. Torres was firm. No, she does not meet the criteria for antisocial personality disorder. One, there's no past criminality with her. That's an element that you need for antisocial personality disorder. Other people with antisocial personality are unempathetic to people and don't care about people. Again, for her entire career, she was a special needs teacher, teaching kids, helping kids who have disabilities. Through her whole life, that had been her career. That is not a psychopath with antisocial personality disorder. That it could be somebody with a dissociative disorder, either DID or borderline personality disorder with dissociative features, who has kept horrible trauma in her past behind her and is trying to make the lives of kids with special needs better for them. That is somebody with empathy who does that whole thing. Ladies and gentlemen, I would put before you the strongest evidence of disassociation going on here. Look at the body-worn camera of the sheriffs when they come in that night looking for Gannon. The most horrible, brutal attack has happened before there. Gannon is in the house in the suitcase. It has all been recently covered up. She's there with her daughter. She's there with Lena. And she is acting and presenting herself to these police, laughing, joking, being incredibly friendly just after this has happened. Because at that point in time, she has disassociated the horrible act that she has committed. There's no other logical explanation for how that she is doing that. And when you go back and look at these timelines, ladies and gentlemen, look and go through them. What is really important during this whole time, she is not sleeping at all. For the whole time here that this is all going on, you see activity going on her phone or things that she's doing all through the night. She is in a manic situation and her mind is not working. Again, we heard Dr. Lewis talk about irrational things that she is doing that doesn't make any sense. Ladies and gentlemen, it makes no sense for somebody who has pre-planned for whatever reason, whatever motive, to brutally kill Gannon, to then report him missing right away, and then in a matter of 3 days later, go into the police with a completely illogical, incoherent story. You heard different witnesses. Ms. Stauch was an intelligent, above average intelligence woman, a smart woman, everything like that. To go in only 2 days later and sit down with the police and come up with the ridiculous story of Eduardo is not the actions of a sane, rational person. It is irrational to believe. Even children know. If you keep saying different stories, you're not going to be believed. Even looking back at the little boy who cried wolf, which we teach children, if you keep making up things, then you're not going to believe. She changes her story, not only completely different, not only with no explanation as to really why she had made up the prior story to one that she is changing now, but comes up with this ridiculous thing that she met this Eduardo, that he was just going to come over and fix the carpet for free. She's not even planning on paying him, that somehow he is in the garage when they get there, that he then takes her down into the basement and rapes her for an hour, and that he takes Gannon in a suitcase and leads out of the home. That are not the actions of somebody who is sane and logical. That is completely irrational to believe that that kind of thing could possibly be believed. Her actions, I would say, continue to be irrational. She keeps changing her story. She keeps giving different accounts. Gannon is placed in the suitcase, driven all the way to Florida. She goes through Louisiana. She goes through all kinds of East Texas, all kinds of places where people are not around, deserted areas, long areas of desolation, many places where that suitcase could have been hidden and never been found. And she goes all the way to Pensacola for it and drops it off on a dry space under a bridge right near a major city. That's not the actions of somebody who is rational, who is trying to hide that away. She then goes to South Carolina, and you can look at the Google searches that she performs in South Carolina. Face transplant near me. Like she's Googling for a McDonald's or a restaurant that's very close to her. That's just going to pop up, that she's going to go over there and get an entire face plant to change the way she looks. Those are not the actions of a sane and rational person. Those are the actions of somebody that is delusional. Ladies and gentlemen, I would say all of these pretext phone calls with Al are the actions of somebody who is delusional. Listen, go back and listen to those February 14th phone calls between her and Al. Listen to how her voice and tenor changes between phone calls. Listen to how her emotions switch rapidly during the phone calls with Al, and her stories switch rapidly that no sane, rational person of overintelligence could possibly expect anybody to believe. She is freaking out, and she is delusional in the thought that anybody is going to believe all the different variations that she's trying to sell them. None of that is rational. None of that makes sense. And so again, what then we're brought back to is why. What was going on? What preceded this? And looking is going to end up in the mental health experts. And I want to talk a little bit about Dr. Lewis. She is 85 years old. She has been doing research, treating, evaluating people with serious mental illness for over 60 years. She is one of the foremost experts in the country on dissociative identity disorder. She has been published in peer-reviewed journals well over 100 times. Things that educates other psychiatrists and things that educates other doctors, she has authored and produced. She has done, she has the HBO documentary. They don't go just to quacks to do an HBO documentary. They went and they did a documentary on her because she was groundbreaking in her field. Had she consulted on other stuff with Robert De Niro and so forth? Yes. Not because she's a quack, because she has explored and she knows more about this subject than almost anybody else in the country. Has she, in her age, some of the details, the minute things in the discovery get lost a little bit in her memory? They do. And you saw that up on the stand when she was testifying. I'm not disputing that. But what she has is the decades and decades of experience with this, the decades and decades of dealing with people with severe mental illness who commit heinous acts. She has that experience to rely upon, and she had 14 hours of interviews with Ms. Stauch to talk with her, to base her opinion. She had notes from family members, other types of things to show this, and in her expert opinion, is legally insane. She wanted the EEG and the MRI to possibly know if there was also organic brain damage going on here. There was some type of brain trauma that was contributing to the mental illness of Ms. Stauch. But what you heard at the end is she did not need those type of things to make the diagnosis of dissociative identity disorder, which she was confident on and she believes upon. Ladies and gentlemen, I would ask you, do not discount her decades of experience. Do not discount her expertise, okay? The acting that, this is a woman who has pioneered this, a woman who has made her life on this, a woman who has been peer reviewed over hundreds of times in different articles on this subject, is willing to throw that all away to come down here at a substantially reduced fee to testify is ludicrous and it's insulting. They pay their experts just the same as we do, okay? And that's why I asked their blood spatter expert, his fees. It wasn't acting like there was anything wrong with that. It's just to show both sides hire experts, both sides pay experts. Just because the expert isn't getting paid doesn't mean that they are money-grubbing liars, okay? Experts in this type of thing, to come and testify, they charge money, they charge a fee. She actually reduced her normal fee to come down and to help with Ms. Stauch and to do this evaluation. And what did she tell you, ladies and gentlemen? Ms. Stauch, of all the hundreds and hundreds of different mentally ill people that she has ever dealt with, is one of the most mentally ill persons that she's ever dealt with. And what else is she saying? I think this is key. Pay very close attention. She's not endorsing that it was definitely Maria that did this. She's not endorsing how Maria is saying this happened. What is she saying? Ms. Stauch has, in her opinion, more than likely disassociated the memory of the homicide because she can't bear to deal with it. That was actually a very good question by Mr. Young on it. And I think there's a lot of validity to that. Ms. Stauch accepting the idea that she committed this brutal, horrible homicide in the manner that was done, smashing that 11-year-old's head in, cannot deal with it. To accept that fact in her mind would crush her, would crush her soul, would crush her identity. And so she has come up with all of these delusional fantasies, trying to come up with some other thing that may have happened. And listen to her voice, listen to the tenor when she's describing that. When she's talking to Dr. Lewis, I can't remember if it's Dr. Lewis or Dr. Torres, about the different versions that she's given, that she was coming up in her mind, hoping and believing it was somebody other than her who did this. The facts, ladies, and we're not disputing that, ladies and gentlemen, it was her. But she was not in her right mind when she did it. And you heard Dr. Lewis state that. And you can look at the evidence and you can look at the other things that go around to realize that is the only reasonable, rational conclusion as to how this horrible thing happened was a psychotic break. Dakota Lowry, who, when he finally realized that his older half-sister actually did this, the first thing that came into his mind, based upon what he knew of his half-sister, was there had to be some type of psychotic break that had happened. That there could be no other explanation as to why it did it, and those are people that knew her and that have grown up with her. I also want to talk a lot, or some, about Dr. Torres. And it is what is important, ladies and gentlemen, to know what both Dr. Torres, Dr. Gray, and Dr. Grimmett is none of the experts that you have heard from that did any type of evaluation think that there's no mental illness going on here. Okay, they all agree there's some type of mental illness. They just disagree over what to call that mental illness. We have Grimmett and Torres and Gray diagnosing her with borderline personality disorder, which is a significant mental illness, which, as you said, comes from right on the border between full-blown psychosis and a neurosis. Okay, it's the most serious of all the personality disorder, and it's so serious because there are such prominent features of psychosis that go along with it. Psychosis where people hallucinate, psychosis where people become delusional, psychosis where people stop becoming irrational. All of that stuff can come and go in people with borderline personality disorder. And it comes and goes according to DSM-5, according to Dr. Torres, according to Dr. Grimmett, when people with borderline personality disorder start to experience high stress. That is why Dr. Niederhauser was important. It was not because Dr. Niederhauser made any type of diagnosis or anything with that, but she came to Dr. Niederhauser because he was experiencing high stress and high anxiety that was causing her to be unable to perform at work. The stress and all of that was mounting. You can look at her Google searches, the Google searches leading up to this. For whatever reason, her stress in life was becoming overwhelming. She felt underappreciated. She felt like running away. She felt like leaving. She felt like this was all too much on her plate, that there was nobody there to help her. And you heard from Dr. Torres about how people with borderline personality disorder feel stress much different than everybody else. Things that would not be normal stressors for all of us can become extremely stressful for somebody with borderline personality disorder. And the other thing that was important that Dr. Torres, we talked about quite a bit, is that it is a lot of the same things, the same type of horrible childhood trauma, the type of trauma where you have one parent who is molesting you and another parent who won't do a damn thing about it, that can cause either dissociative identity disorder or borderline personality disorder. They both come from the exact same environment that Dr. Torres said Ms. Stauch grew up in. That type of environment is what can cause people to have borderline personality disorder, which then under periods of stress and anxiety can become psychotic. And I think one of the other things, and I think is something to look in and something I want you guys to think about when you go back in that jury room, is something that Dakota Lowry said at the end. We don't know exactly all the intricacies of the trauma, of the abuse that Ms. Stauch suffered. We don't. Some of that she knows about, some of that she's come to remember, some of that is locked away, some of that is hidden by other family members who don't want to admit it. But what did Dakota talk about when he was a kid and after his stepdad has died and his mom had moved on to another abusive alcoholic in the home and Ms. Stauch would come visit him? What would she do? She would leave him with knives to protect himself from something or someone. And the fact you can draw that Ms. Stauch sometimes as a kid going through that trauma either had to protect herself with some knives or fantasized about having a knife to protect her. And then you have the connection between Gannon being stabbed 18 times with a knife. Some of these things are hidden. Some of these things are hard to look at, but there is that association there between what we can assume was some of the childhood trauma that Ms. Stauch suffered, how she dealt with it, and how this horrible thing happened to Gannon. And I understand that Dr. Torres didn't think she was insane, but you can't discount the fact that Dr. Torres readily admitted borderline personality disorder can be a serious mental illness. People with borderline personality disorder can suffer psychosis. People with borderline personality can become irrational. People with borderline personality disorder can disassociate things that the whole person cannot deal with. And that disassociation explains all of these crazy cockamamie lies. It is a fantasy on Ms. Stauch to try to explain this horrible action that she cannot rectify in her home with. And whether you call it borderline, whether you call it DID, I think Dr. Lewis is correct. That is not necessarily the important thing. What the important thing is look at the facts overall and realize this must have been some type of psychotic action going on, because normal people mentally healthy, normal people don't one day go on a hike, take smiling photos, and the next day stab a kid 18 times for no apparent reason. And no matter how much Mr. Young would like her to be antisocial personality disorder, and he would like that because that takes insanity off the table, none of the evaluators ever have diagnosed her with antisocial personality disorder. None of the diagnoses ever have even had the rule out antisocial personality disorder. Antisocial personality disorder is something that is always considered at the state hospital, but there are criteria, and she did not meet it. No matter how many times in different ways Mr. Young tried to act, asked Dr. Torres about it, she was firm and said, no, that is not the diagnosis that we have given her. That's not the diagnosis that Dr. Gray gave her. It's not the diagnosis that Dr. Grimmett gave her. And it's really not the diagnosis that Dr. Lewis gave her. So all the antisocial personality disorder talk is a smokescreen. And when you take the antisocial personality off, the only thing that explains her conduct afterwards is disassociation, is disassociating from the horrible thing that she has done. And she's trying somehow to fix this or to get out of it. The other thing that I want to talk to you, and it's important, that was very apparent with Dr. Torres, Mr. Young would like you to believe that the only time somebody is legal insane if they commit the crime and they just stay there saying, yeah, if it was me, I did it for these reasons. Dr. Torres and the jury instructions from the court state somebody cannot know right from wrong, but still recognize that their conduct was criminal when it occurred. And so you heard from Dr. Torres, just because somebody in a state of psychosis, in a state of insanity, commits a horrible murder and then tries to cover it up, the covering up of the murder does not preclude insanity. And she talked about how there are cases that she has had where somebody was insane who then tried to cover up the acts that they have done because they didn't want to suffer the criminal repercussions. They are not mutually exclusive. That's not coming from me. That's coming from the instructions that you have from the court. Ladies and gentlemen, you guys have been above and beyond in this. And we are very grateful for the time that you guys have given us, the thought that you guys have put all into this, the sacrifice in your lives that you have made through this long trial. I'm not going to rehash every detail on here. You guys know it. You guys understand it. You guys have heard the experts. You guys can put all this stuff in there together. We are asking you to find her not guilty by reason of insanity. We're not saying set her free. We're not saying let her go. We're not saying don't hold her responsible. We're saying for you to take into account the mental illness that she suffered and send her down to CMHIP, where you see how it is down at CMHIP during those interviews with Dr. Torres, where she's shackled fully, where there's constraints, where it's a locked facility, and that's where Dr. Torres told you if you find her not guilty by reason of insanity, that's where she is going, where there is repercussions, but there is also treatment for the mental illness that she has suffered from her entire life. The other thing that is important, I just want you guys to remember, is the burden of proof. It's not whether you decide, oh, I think that she was psychotic at the time, is have they presented enough evidence before you that you can say, without a doubt, there is no way psychosis was involved here. Have they completely disregarded that? Have they completely wiped it out? And I, ladies and gentlemen, I would put before you with all the different doctors diagnosing her with some serious mental health illness, with their witnesses, they called diagnosing her with a mental illness that has transient periods of psychosis, when psychosis appearing to be the only rational explanation, but no other motive for this horrible thing, with the overkill that was involved here, with the irrational behavior afterwards, even up and through some of these interviews, even up and through some of the trial, all of that points to mental illness. And in no way, shape, or form have they disproven that. And it is their burden. And so if you believe that it is possible that this occurred in a state of psychosis, your legal duty, which you have sworn to do, is to find her not guilty by reason of insanity. And that is what we are asking you to do. Thank you.
Council approach, please. All right, ladies and gentlemen, the prosecution does have a right to a rebuttal, and they are going to exercise that right. But you've been sitting there for a while. So what we're going to do is take about a little bit more than a 10-minute recess, give everybody some time to stretch, use the bathroom, those sorts of things. So if I can have everyone back in the...
Ladies and gentlemen, the only fantasy in this courtroom is that this defendant, this stepmother who killed Gannon, has psychosis, that she was insane on January 27th of 2020. That is the only fantasy that has been brought out into this courtroom. It's been brought out by this defendant. They want to talk to you about motive. We talked to some of you in jury selection about motive. One thing you didn't hear the judge read in any of those instructions is anything about motive. You know why? It's not an element of a single crime under Colorado code. We don't have to prove motive, and yet we did anyway. This defendant hated Gannon. You know that because she searched it. I hate my stepson. She has one stepson, and she hated him. She was planning to leave Al Stauch, move back to the East Coast. She wanted to hurt Al. She wanted to hurt Landon, for that matter. She did, to the core. They will never recover from what she did to them, ever. And you know that. Think about the time frame that we're talking about. This was no snap in time. This was not an instantaneous thing. This occurred over days. She was planning to leave a week prior to Gannon's death when she killed him. Look at the searches that we talked about on Monday when Kevin Clark took the stand. We know when she was looking to leave. We know she hated Gannon. She knows she wanted out of a marriage with Al. We know that she didn't like what Landon was up to because she would manipulate Gannon about Landon. We know these things because of the evidence that we brought you. And in fact, it does prove motive. I want to ask you about why did Al leave Gannon with the defendant on that weekend? He left on January 25th, Saturday. Remember that? Why would he leave and go to Oklahoma for 2 weeks of training if he knew there was a problem with the defendant from psychosis? Al told you the answer to that question. He would not have gone. If he had seen some problem with the defendant, he said he would not have gone. And he did anyway, because she doesn't have psychosis. He never saw a single sign from her. What he didn't know, unfortunately, he couldn't see into her heart. He couldn't see the hatred that she had for Gannon, the motive that she had to leave and to hurt him to the core. He didn't know that it was all about her, even though he lived with her for some number of years. Defense wants you to speculate that the fire set off some sort of a trigger. You read those instructions while the judge was reading them to you. It says speculation. Can't do it. And yet they're inviting you to speculate. Why is that? Why would they invite you to speculate when we're talking about an 11-year-old boy who was brutally murdered? Why would they invite you to speculate? Because they want you to ignore the evidence that was brought into this courtroom. They want you to ignore this evidence and speculate on the other hand. You can't do it. Saying she's freaked out in that phone call. Acting she's freaked out. We all get freaked out sometimes. As Mr. Young said, we're human. Go drive down the highway and you see an accident, you might freak out, you might have some rush of adrenaline, and it kind of messes you up a little bit. That's human. Not psychosis. And further, that freaking out that she's supposedly doing is her acting. It's not psychosis. It's all about Letecia. It's all about this woman who murdered Gannon throughout the whole thing. The text to the school, to Leslie Hicks, that morning, January 27th. They want you to speculate again that that's some sort of a trigger. You know what it is. It's an unassailable excuse. You tell your employer that your stepfather, a member of your family, has just died in a tragic car accident. No employer is going to make you come into work that day. She needed an unassailable excuse to not go to work because she knew what was happening later that day. He knew Gannon was done that day. That's why she calls Gannon into school later, or out of school later. The timelines that we brought to you on Monday, her internet searches, tell you everything you need to know about her mental condition. She was calculating, manipulating, lying to everyone. Why? Because it's about her, not about Gannon. Deflect the blame and make herself the victim. Does it ever make sense when somebody kills another person? Can it ever truly make sense? Can it ever truly make sense when a parent kills a child? The answer to that is no. None of us in this courtroom, except one, has killed a child. That doesn't make it a psychotic act. That doesn't mean somebody's insane. Unfortunately, way too many people kill kids in this country. Why do they do it? Who knows? But it's not psychosis when this one did it. Be very careful when people introduce facts. Mr. Tellini got up here and wanted to introduce facts to you. inviting you to speculate. Be very careful about that. He tries to brush away the effect of the hydrocodone that was found in Gannon's system. First of all, Gannon should not have had hydrocodone in his system. Dr. Ignacio told you about that. It's not typically given to 11-year-old little boys. Why not? It's an opioid. It can cause people to get sluggish, lethargic, and lead to coma, and stop you from breathing, and can kill you. All of those things that hydrocodone, an opioid, can do to you, this woman did to Gannon. Why? Because she wanted to kill him. Mr. Cellini brought up the idea that the brutality itself proves psychosis. Is that true? Does the brutality itself prove psychosis from this defendant? The evidence has the answer for you. The defendant's own actions has the answer for you. The brutality of it speaks to the abject hatred she had for Gannon and the pure determination she had to kill Gannon. This didn't start in one snap moment. When did this start? Sunday night. Sunday night with the candle. A candle incident that makes no sense, according to the way that she describes it to people, because she wants to make it Gannon's fault. Does that make sense? Mr. Stauch told you the answer to that question. Harley told you the answer to that question. Gannon didn't play with fire. He would never go downstairs and just light candles randomly. He had a long history of having stomach issues, where he'd get backed up and then have issues with it. And yet this day, he poops himself, and so he's got to go burn a candle to mask the smell, even though he'd never done it any other time in his entire life. Does that make sense? Or does it make more sense that this defendant burnt him? That's the start of the attack, ladies and gentlemen. Sunday night. And it continues with a hydrocodone. A prescription for a full-grown man is given to Gannon. That goes into the morning time. That's why he's lethargic. He can't get out of bed early like he normally would. He's walking slowly to the pickup truck at about 10:15 in the morning when they leave the house, because he's under the influence of hydrocodone. And then she drives him around, leaving him in the car. He's probably passed out in the car. Doesn't make any sense to leave an 11-year-old boy in a car unless there's something wrong, something that she did to him. And this picture from Garden of the Gods, these two pictures that she sends Al Stauch that morning of Gannon in bed. Mr. Cellini again is inviting you to speculate as to the reason for those pictures, saying she's just a loving stepmother. What are those pictures? Think about that picture from Garden of the Gods in relation to the pictures that she sends Al Stauch. They're proof of life pictures. They're pictures that she is sending out, prove to the world that she had nothing to do with what she's about to do. Why would she send pictures of Gannon in bed to Al Stauch, except for a proof of life picture? A way to cover her tracks, and it starts early, right? They want you to think that this was some sort of a temporary snap. Said it on opening statements when Mr. Cook dramatically walks out of the courtroom, says this is way too worse, we can't handle this. It's a crack in her psychosis. And then we hear it again today from Mr. Cellini. First of all, temporary insanity is not what our insanity statute is in the state of Colorado. Look at it. That does not apply here. Second of all, there's not a temporary insanity moment in this case. It starts from Sunday night and goes all the way through Monday evening. Almost 24 hours of horror that Gannon had to suffer at the hands of this defendant. What should have been the safest place in the world for Gannon to be. People who live by stories, by telling tall tales, don't stop. Why would she stop doing that once this case started, if she'd been getting away with it her entire life? Think about the manipulation that she carried out on everybody else in her life. Al told you about the manipulation. Everything this woman did in her life was manipulation to cause chaos, to make her the victim and the focus of everything. Every single thing. Harley. She didn't know how her own father died. Because she was lied to by this defendant. Why would she stop lying when the biggest thing that she's ever caused in her life is being drilled into by an investigation that is the biggest El Paso County has ever seen? That involves the FBI. That's who she is. She's a storyteller. Telling fantastic stories is not psychosis. It's who she is. She starts looking up face plant surgery centers. She starts looking up, I need a new social security number. I need a marriage license. I need a replacement passport because El Paso County Sheriff's Office has mine. And she looks up fake polygraph. Why in the world would you need a fake polygraph unless you're covering your tracks? To have some sort of thing that you can anchor a legitimate story to that you didn't have anything to do with this case. Why? Who thinks of that stuff except for people like this? I would venture to guess that not a single one of us in this room ever even knew a fake polygraph website existed before now. I know I didn't. Let's talk a little bit about Dr. Lewis. She might be a world-renowned expert. She's the only expert that they could find to bring in here to tell you that this defendant had dissociative identity disorder. Not a single other doctor that testified here in this courtroom saw a single shred of evidence that she had dissociative identity disorder. Not a single one. And yet this doctor comes in and says she does have it. This doctor comes in and says she does have it, yet she doesn't even know what the definition of insanity in Colorado is. She starts throwing around words like McNaughton and other things that might apply in other states. And she said sanity could depend on where you are, what state you're in, that kind of thing. Don't you think if she's going to come in and tell you as an expert, this defendant is insane, according to Colorado law, should know what Colorado law is, and she couldn't do it? There were a lot of I assumes, I don't knows, deflections, stories about other cases. Anytime she was pressed to justify her opinion, she couldn't do it. You saw Dr. Torres in contrast to that. She could point to specific things about her evaluation of the defendant. Compare the two. The instructions that you got from the judge are your roadmap for this case. They help you determine what the law is, and you're expected to follow the law, and you apply that law to the facts in the case, to the evidence that's been piling up over the last several weeks. The presumption of innocence absolutely applies in every single criminal case. It applies in this case. Until you are determined that the charges have been proven beyond a reasonable doubt, she has the presumption of innocence. We have the burden of proof. This system doesn't work if you don't hold us to our burden of proof. We expect you to hold us to our burden of proof. We welcome you to hold us to our burden of proof. Mr. Tellini talked about proving it without a doubt. Proving this case without a doubt. You'll never see words like that in any jury instruction in the state of Colorado or in the United States. You don't have to prove cases beyond all doubt. You have to prove things beyond a reasonable doubt, because this is, after all, a human function. Nobody can ever prove anything 100%. Johnny Cochran, after the O.J. Simpson, or in closing for the O.J. Simpson case.
Your Honor, I'm going to object to represent Johnny Cochran and O.J. Simpson. I think there's no evidence of it. It's not commenting on evidence.
I'm sorry?
It's not commenting on it. There's no evidence of what Johnny Cochran did at any point in time. So
I'm actually using it to talk about the burden of proof, Judge.
well, then rephrase it.
Well, I was about to. So in that case, Johnny Cochran said, if it doesn't fit, you must acquit. What he's talking about is our burden of proof. And he was absolutely right. If a case is not proven beyond a reasonable doubt, your jobs as jurors, according to these jury instructions, is to find a defendant not guilty. And we expect you to do that. If we didn't prove the case, then hold us accountable and find her not guilty. But if we did prove the case beyond a reasonable doubt, the jury instructions are also very clear on that. If we have proven the case beyond a reasonable doubt, the jury instructions tell you, you should find her guilty. If the crimes fit, you should convict. That's what the jury instructions say. And that's the other side of the coin from Johnny Cochran's comment. If the crimes fit this defendant, convict her. Deliberations are up to you. When you get back into the deliberation room, you get to control how that deliberation goes. The only requirements are that you all have to be together when deliberations are happening. You have to do it in the jury room. But you can take as long as you want, and you can be as fast as you want to come to a conviction or to a decision. Nobody's ever going to second guess you. If you take 2 weeks or 10 minutes, it's up to you. What we do know, what you should know from the evidence, that there's plenty of evidence to find this defendant guilty based on the evidence, not from what I say or what Mr. Young says, or find her not guilty because Mr. Tellini and Mr. Cook say so. The evidence guides you. Let's talk about that question of sanity. It says, so diseased or defective in mind to be incapable of distinguishing right from wrong. Can this defendant distinguish right from wrong? The evidence and her actions tell you that she can. Why do all the things she did if she didn't know what she had done was wrong? Or she suffered from a condition of mind caused by a mental disease or defect that prevented her from forming a culpable mental state. What is evidence of that culpable mental state? As Mr. Young said, it's in Gannon. It's on Gannon's body. The evidence that Gannon's body provides you, the story that tells about what she did, shows she has the ability and had the ability to form the appropriate culpable mental state. You don't stab an 11-year-old 18 times, 11 of which are on his arms and hands as he's defending himself, unless you intend to kill him. You don't then dispose of that knife that's never recovered and hit him over the head with such viciousness 4 separate times that it cracks his skull open, unless you intend to kill him. And that blunt force object, also never found. And then you don't retrieve a handgun, a 9mm handgun, and squeeze that trigger 3 intentional times, hitting Gannon 1 time, unless you intend to kill Gannon. That's exactly what this defendant did. And that's how you know she could form the appropriate culpable mental state. This woman doesn't have a diseased mind. She has no psychosis. Multiple doctors and longtime family friends and family members answered the question of psychosis for you. This defendant knew then and knows today the difference between right and wrong. Harley said it. Dakota Lowry said it. Al Stauch said it. Every single person that knew her knew she knew the difference between right and wrong. She was of sound mind, informed the culpable mental states required. You learned about dissociative identity disorder from at least 2 different doctors in this case. Extremely rare. Prevalence in society is roughly 1.4%. But most importantly, it's marked by severe behavioral health symptoms that would be noticeable by others. Other people like Harley Hunt, her daughter who lived with her every day of her life. Al Stauch, who was married to her for 5 years. Dakota Lowry, who was her younger brother. These people would have noticed that she had something wrong with her. The forensic nurse examiner, Amanda Van Nest at the hospital, would have noticed it. This is 2 days after Gannon is murdered, and the defendant fakes that panic attack in the sheriff's office and is taken to the hospital, given the opportunity to be examined for the supposed rape story that she had. And she splits. Amanda Van Nest told you that she's dealt with people with severe mental health disorders. She's told you what happens when she deals with people like that. Called an M1 hold. It's an emergency situation where you put somebody in care for a period of time because they're a danger to themselves or to others. Amanda Van Nest saw no sign that this defendant was anywhere close to justifying an M1 hold on January 29th. Dr. Niederhauser, on the other side of this equation, about a month before Gannon was killed, the last medical professional to see the defendant before Gannon was killed, also familiar with M1 holds, and saw no signs that would justify holding her against her will because she was a danger danger to herself or others, because she wasn't. She didn't have psychosis. Why blame others? First, it's Gannon's fault, right? He pooped all over himself, started a fire. He's experimenting with drugs. Isn't that convenient that he's experimenting with drugs? He's curious about bath salts. And there's a Swisher Sweet planted in his backpack. And he's got hydrocodone in his system. Isn't that convenient? Isn't that convenient concoction from this defendant Then she says he went to a friend's house, didn't come home. Or is it because he loved his mom too much? He was a mama's boy. Is that the source of her hatred for Gannon? She knew she could never replace the love that Gannon had for Landon. And she concocts Eduardo, some random Mexican guy that works at the housing development. Just gives him access to the house through the garage code. He comes in, fixes the carpet. But in addition to fixing the carpet, he rapes her. Bangs her head on the floor. No sign of injury on her. Curiously asks for boxes in a suitcase. Why'd she have to introduce the suitcase? Had to explain away why Gannon was going to be found in the suitcase she put him in. A suitcase that Al Stauch recognized when he was shown the picture. The suitcase that Dakota Lowry recognized this defendant struggling with before she drives off to Florida. We had to explain it away. Next, it's Quincy Brown's fault. You heard Special Agent Jonathan Grusing. He talked about he wishes he would have pushed her more on the Quincy Brown and let her expand on that character, because this is the character she gave the most information about. It's a real guy. Guy that was published in the media. The most wanted people in El Paso County for sex offenses. Perfect fall guy for what this woman did. He replaces Eduardo as the rapist. Knew his name when his ID fell out conveniently and landed on the floor in front of her. Then he turns into a guy up in northern El Paso County selling a bike. Or he's laying in the road as they're driving and gets into the car and forces them to come back home, and he rapes her there. Or Gannon's test riding a bike, crashes, hits his head, and then he takes off with Gannon. Uncle Matt, the least descriptive person in any story this defendant has probably ever told. Boy, can she tell some stories, can't she? Somehow Gannon knew him and he was involved, but we don't really know how. And then it's the pregnant lady with the cash baby. Supposedly 8 months pregnant, involved with money laundering for Mexican restaurants, gets into the car, starts pulling money out of her belly. Somehow she's involved with what happened to Gannon. She's pointing outward, right? Pointing anyway, except for her. Except that in each one of these stories, the blame for Gannon's disappearance is someone else, and she's the victim in every single one of these stories. Figuring out a way to cast blame elsewhere and situate herself as the victim as to what happened. That's a very calculated move. Every single time she does it, she's doing it to explain away why pieces of evidence are found in the case. She knows about the suitcase is going to be found. She notices that we're searching up in northern El Paso, southern Douglas County, where the board is found. So that's when the bike story comes in with Quincy Brown up in that area. She's got to explain away why her GPS is going to show her up in that area. Just up there innocently looking for a bike. But Gannon's blood is going to be found up there. Got to explain it away. Landon's fault. This is the most cruel of all, right? That somehow Landon is responsible for a Gannon because of her ex-husband. That somehow Landon is involved with Gannon ending up in Mexico. Why would she introduce the word Mexico? Because by the time she's saying this, she's already pitched Gannon over that bridge in Florida, thinking it's pitched over into the Escambia River that flows out the bay and into the Gulf of Mexico. It's Al's fault. His fault that Gannon is gone and he should be investigated. Somehow he contaminated the scene. Another cruel twist of the knife. Going after the people that Gannon loved the most and who loved him the most shows you the hatred that she had for these people. The hatred that she had for Gannon and how she's going to use Gannon's horrific demise against the people that loved him the most. Her stepfather, James, supposedly sexually assaulted her as a kid. It's his fault that she's the way she is. Except there's not a shred of evidence from anybody until she starts raising competency that she ever suffered any sort of ill harm by James. She never reports it to a single person for over 20 years. And yet that's the trigger. Does that make sense? There's the caped invader's fault. It's the last one, right? Standing on top of the bed, wearing a cape, then realizes it's Gannon, but she shoots him and stabs him and does all these other things to cover up for whatever. Does that make any sense? Or is this just another concoction? Another way to point outwards on blame and show herself as the victim? When she realizes those external sources aren't working, Dr. Dorothy Lewis comes into play. Before she looks at a shred of evidence, in February of 2022, she's already said, yeah, you need to go with not guilty by reason of insanity. Dissociative identity disorder is the answer. Doesn't know a single thing about this case or this defendant in February of 2022. And so what does this defendant do but start creating names? There's Taylor, Harmony, Christina, Jasmine, the Frisky Princess, Little Lucia, and Maria Sanchez. Spanish-speaking Russian sniper. Knows how to kill, kill, kill. One thing we do know from this evidence, this defendant knows how to kill. Knows how to kill a defenseless little boy in his bed. There's better words to describe this defendant and what she did. Unreliable. Every person that she's ever interacted with in her life can tell you that she's unreliable, that she tells tall tales. She hated Gannon. You know that because of the injuries that Gannon suffered. You know that she hated Landon and Al. Why take away their little boy the way she did and concoct the story she did unless she hated them just as much as she hated Gannon? She planned this. A week before Gannon goes missing, she's already looking at renting a U-Haul and places to live in Florida. Sometime prior to Gannon's death, she searches, I hate my stepson. Premeditated this thing. You know that from the proof of life photos. Those two pictures that she sends to Al on the morning of January 27th. She's setting up her excuse. Portraying Gannon as experimenting with drugs when she knows that she's drugging him with hydrocodone. She burned him Sunday night when this all starts. Gannon didn't play with fire. Not going to intentionally burn himself. In that first story about the candle incident, she talks about taking the kids outside and then having to go back downstairs to get Gannon. They all pile in the truck and drive off. That never happened. This was just a story that she had to explain away because the fire didn't work. Gannon didn't die from the fire. Then poisoned him with the hydrocodone. That didn't work. Remember, Gannon was a fighter. 1 pound, 6 ounce little boy when he was born. Overcame all the odds. But he couldn't overcome this one. But he sure did try, didn't he? She attacked him, stabbing him 18 times. Like I said, most of those are on his arms and hands because he's fighting back. Beat him over the head 4 times with some blunt object that's never found, cracking his skull like an eggshell. Shot him in the jaw, severing his spine, and likely killing him instantaneously. She then manipulated the heck out of this investigation with her stories. Her stories and manipulations of this investigation caused it to be the biggest investigation in El Paso County history. I heard that from several different investigators involved in this case. And it stretched from Colorado Springs all the way to Myrtle Beach, South Carolina. She hid Gannon's broken, dead body in a suitcase in that storage room. She ran from cops when the circle was tightening. Remember that trip to Marshall's? When the cops are going there to get cell phones and get the car that belonged to Harley? And they encounter her out in the parking lot. She takes off running. As soon as she sees those guys, she takes off running, throws the keys across the parking lot, starts yelling at Harley, don't say anything. Why? If she didn't know she had done something wrong, why? Then fled to Florida and then eventually South Carolina. Get as far away from this thing as she possibly could. That's why she's wanting to get a replacement passport so she can escape the country. She dumped Gannon's body over the bridge. Mr. Young talked about this. Think about how divine intervention plays a part here. Macon Ponder had been at that bridge a month and a half before then. Gannon's body doesn't get found for at least 2 years, if ever. She murdered Gannon. January 27, 2020. She murdered Gannon. This little boy deserves so much more out of this defendant. He deserved protection. He deserved to live. He deserved to grow up and become a young man and someday have a family of his own. She took it all away.
People are not starting 911 to the feedback location of the emergency. Well, 667 Linden Drive, Colorado Springs. Okay, so that one more time, make sure I have this here correctly. 667 Linden Drive. Okay, so number you're calling. 843-55-7460. Your name? Pizza. Please tell me, sir. What happened? I don't know if I'm sort of emergency or not emergency, but my son says we all at the house and it's under 7. We went to like our friend's house and everybody's going to be at the friend's house and they said he wasn't there and the other said he never came there. I don't know any other people calling out, and I talked to my husband, so I told him I had to call you guys exactly that too, because I don't know anyone else. And I don't know if there's like a time limit, but like he's only 11. He's 11. 11, yeah. Okay. What's his name? Gannon. For me? You for an open. Your last name? Stauch. Stauch. I got a hard time every day. If I have information and I think you have multiple questions, we have to ask them what I'm trying to emergency. That's fine. That's how I know which one I'm going to say. You know when you're ready for that number. Okay, go ahead. 719. Okay, can you put me on? 19. 390 5555. Okay. You're welcome. Call that now. Call that now. I already have the call, Bill. We have things to ask. So, you can call back tomorrow. We'll be left. I do. Can I get back to the city? How can I help you? Hi, yes. I called 911, and they said I had to call the number because I let you know if I was supposed to come on the street. But we didn't. I know it's already said this, but like we went to both the friend's house and they said he wasn't there. And it was kind of like a thing and stuff. I was like, what's your last name? Maybe around like what time did you guys go today? Is it 3:30 maybe? Between 3:34 and you were supposed to be home at 6. We let them all the time, like into the neighbor's house, friend's house, they ride bikes and everything together. Who was the last person to see him? I guess me.
Ladies and gentlemen, you can go back into that deliberation room and start deliberating. Gannon deserves justice. This defendant deserves to be convicted based on the evidence that was presented in this case. Gannon Jacob Stauch, 11 years old. Find the defendant guilty of murder in the first degree after deliberation, murder in the first degree, child under 12 in a position of trust, tampering with a deceased human body, tampering with physical evidence. Gannon deserves it. Deserves all of this justice that you can give him. Thank you.
Cheryl, can you get her those lists, please? Thank you.
All right, ladies and gentlemen, as I indicated earlier when I read the instructions to you, there are 4 verdict forms, one for murder in the first degree after deliberation, one for murder in the first degree child under 12 by a person in a position of trust, one for charge of tampering with a deceased human body, and one for tampering with physical evidence. In a moment, I'm going to send almost all of you back to the deliberation room. And members of the jury, I want to thank you for listening so closely to the evidence in this case. Because most or all of you have not served as jurors before, I would like to give you a few pointers regarding the process of deliberation. However, unlike the instructions that I gave you, these are only suggestions, and you are free to proceed in any way you wish. First, you may wish to choose your foreperson who will preside over your deliberations. You may already have a good idea of someone that you think would be fair, a good listener, and a good discussion manager. Pick someone who is willing and able to help the discussion remain organized and respectful. Remember, however, that the foreperson's opinion has no greater value than that of any other juror. Second, you should reach some agreements about how you will conduct yourselves. The foreperson shall enforce or encourage compliance with these agreements. If he or she is unable to do so or engages in this conduct him or herself, the jurors have the right to select a new presiding juror. Jurors are often tempted to hold a preliminary or straw vote at the beginning of deliberations in order to determine whether they already agree or how divided the group may be. I recommend against this procedure because it may cause some jurors to lock themselves into a position which they will then feel reluctant to change. Experience has also shown that such early votes frequently lead to disruptive, unnecessarily lengthy, and inefficient debate and to ineffective decision-making. If you reach a particularly controversial or difficult point in the discussion, you may want to move to a less controversial or simpler area for discussion and return later to the more difficult issue. You may wish to consider secret ballots if the jury would feel more comfortable with this procedure. You each have the right to your individual opinion, but you should be open to persuasion. It helps if you are open to the possibility that you might be wrong, or at least that you might change your mind about some issues after listening to other views. Misunderstanding can undermine your efforts. Seek clarification if you do not understand or if you think others are not talking about the same thing. The foreperson or some other juror as agreed to by the jury may wish to take notes of agreements and disagreements and, from time to time, set out the items on which you agree and those on which you have not yet reached agreement. You must deliberate as a group while you are all together. In spite of your best efforts, it is indeed possible that serious disagreements may arise. In that event, recognize and accept that getting stuck is often part of the decision-making process. It is easy to fall into the trap of believing that there is something wrong with someone who is not ready to move toward what may be an emerging decision. Such a belief, however, is not helpful. It can lead to a conflict of personalities rather than a conflict of issues. It is best to be patient with one another. Taking a break can often be helpful and lead to a satisfactory conclusion. The bailiff is available whenever you need to stretch, to calm down, clear your minds, take a walk around the building, something of that nature. As I indicated, however, these are only suggestions, and you are free to proceed in any way you wish. When we began this process, I told you that we were going to be selecting 12 jurors plus 6 alternates. The reason why we do that is because in any case that lasts for longer than a day, if something were to happen to a juror during the process, I would have to declare a mistrial, start all over on another date at another time from the beginning with a whole new different crew. This was the first trial of any length that we've had since COVID. I have had long trials before, and I understand that things happen during trial. Sometimes people have family emergencies during trial. Sometimes people get sick. Sometimes, as in this case, we had a juror who didn't know that they knew a witness until that witness got here. So we always try to plan for that because we don't want to have to put everybody through another trial at a different time and start all over without any potential of resolution and without any potential of getting through all of the evidence. However, the law only permits 12 people to deliberate in this case. The alternates in this case are chosen at random. I'm still going to refer to you as number to protect your privacy. So we have 9 people in the back, number 10, number 11, number 12. You're 13, 14, 15, 16, 17. 13 through 17 will not be deliberating. I'm going to excuse jurors 1 through 12, and Mr. Combs will take you back to the deliberation room. And there should be, do we have food? There should be food, or food is on the way. We are working on that. So please be patient with us. But we're going to send 12 of you back now. The other 5, please remain in the courtroom because I have further instructions for you. I'll rise for the 12 jurors, please. There. Thank you. May all be seated. Records should reflect that the 12 jurors have left the courtroom. We get to this point in every case, almost, any case that lasts longer than a day. And I always feel terrible for the people that are the alternates because you have put in just as much time, effort, and energy as everyone else. You have dedicated a lot of time to this case over the last 7 weeks, 8 weeks, wherever we are. But you don't get to deliberate yet, which is why it is possible, and we just had it happen last week in a different case, where one of the jurors had to be replaced by an alternate. So this is going to sound a little strange. I'm going to release you, but you're not excused from jury service. What that means is that you're not going to be deliberating back with the 12, but you still cannot discuss this case among yourselves, cannot discuss the case with anyone else, cannot do your own independent research about any aspect of the case. The reason for that is it is possible that I would still need your services if something were to happen to one of the jurors that is deliberating. What I'm going to do is I'm going to have Mr. Sproul take you back to an alternate jury room because you guys have two of them back there. But I want to have a conversation with you about some security things and some publicity things and also some services that we offer. So I want to have that conversation with you before we discuss anything further. And you're welcome to stay in that jury room for the rest of the day. You're down here. I don't know what you want to do. We can talk about that, but we'll talk about all that back there. I do have certificates of service for you. And I also have a questionnaire, which I'm going to ask you to fill out. It's something that the state of Colorado sends out to jurors. So if you would take the time to fill it out, and I'll be back to talk with you in about 10 minutes or so, I'd greatly appreciate it. All rise for the jurors, please. Thank you. You may all be seated. Record should reflect the jury has left the courtroom. I have a couple of things, some announcements, primarily an advisement, I suppose, more than anything else. First of all, I will need contact information, clean laptop, and for anyone who's listening or interested in the ultimate outcome of the process, the plan is that once I am advised that a verdict has been reached, I will be contacting Mr. McCallum and Mr. Sarche, who are the public sort of information officers for the Colorado Judicial Branch, and they will send out a tweet. I'm going to, I will not be taking a verdict until 30 minutes after it has been announced, or I'm sorry, until 30 minutes after I send that to Mr. McCallum and Mr. Sarche. So the plan is that everybody will have 30 minutes time to be able to get back in place, and then we'll take the verdict. I also want to thank the attorneys for their presentation in this case. More importantly, I want to thank the lawyers for the presentation or for the professionalism that they have demonstrated throughout this trial. This was a long trial. It involved difficult facts. I know it was hard on the jury. I know it was hard on the families. I know it was hard on the defendant. I also know it was hard on the lawyers. This case was logistically complex. There were lots of witnesses from lots of different places. All of that had to be coordinated to get them here. There was a lot of evidence. I think I've spoken with the court reporters. We're getting a little bit better at it, but it still takes us about 20 minutes to get all of the evidence from the courtroom into the evidence room at the end of the day. And the lawyers had to review all of that, both sides. They had to figure out how each piece of evidence related to a different piece of evidence and what witnesses related to what pieces of evidence. One side had to put all of that together, and the other side had to figure out how to defend against it. That both sides had very difficult jobs, but with the exception of one or two exceptions, at least as far as I could see, you acted professionally with each other and respected that opposing counsel had a job to do. In a case that could have been made so much worse by bad lawyer behavior, all of you rose above that. I appreciate that. From a judge perspective, it may not mean much, but from a judge perspective, I think you have put on a clinic for how cases should be tried. I've always thought professionalism among lawyers ultimately benefits the client, but I know that not everyone agrees with that. So, but I wanted to thank the lawyers for the presentation because I know how difficult this case was for everybody. So we need contact information for the lawyers. I've given an advisement as to how the verdict will be handled. And I suppose if there are any questions, we'll take up the issue of